And Mr. Jordan?
This is Miss Champion hosting.
Okay. Is there any way that you could place myself and Attorney Sterling Stephenson in a breakout room?
Okay, yes, I will.
Okay. All right, thanks.
Miss Champion, can you place me in the same breakout room, please?
Oh, yes, and in course.
Good morning, everyone.
I just did mine.
You did yours? Okay. All right, everyone, are we ready to begin? Thank you for your patience. It's been an interesting Tuesday morning.
Morning, Judge.
Good morning.
Morning, Judge.
Morning.
Morning, Your Honor.
Good morning. Let me at least bring us to order. Today is Tuesday, September 20th. This is the state all-purpose calendar for the State Court of Fulton County. I am Judge Regina Mincy, and I will be presiding today. Who do we have first, Deputy? Let me also say one quick announcement, just to inform the defendants on this calendar that this whole entire proceeding is being live streamed and on YouTube and recorded. So govern yourselves accordingly. You do have some constitutional rights that we want to make sure that you are aware of. You have a right to have an attorney at this proceeding, which most of you do. And you also have the right to remain silent. Remember that anything that you say about the facts, the circumstances, or the occurrence of your case can and will be used against you at a later date. And so please listen to your attorneys and govern yourselves accordingly. All right, who do we have first, Deputy?
We have position 18, Mr. Kilgore.
18, okay.
Good morning.
Good morning.
This is Attorney Beverly Taylor. I represent Mr. Kilgore.
Okay. Have you filed your entrance?
Judge, I did. We're checking it this morning. I think it's one of those situations where we filed it in, and I guess Odyssey didn't accept it if it's not showing.
Okay,
But the defender did contact me on yesterday to let me know that Mr. Kilgore was on the calendar today. So
Okay.
we will make sure that we get the entry and discovery motions filed in. For today, Judge, we're just going to enter a not guilty plea, maintain the not guilty plea, and ask for 10 days to file additional motions.
okay, so this,
I'll get the entry and some consolidated discovery motions filed in today.
okay, great. And are you aware of the offer at this point?
Based on what, and I keep saying public defender, I wanted to call her name. Miss Heller, is it Helen? Yes, based on what she told me, I'm aware of the offer, Judge. I do want to review the discovery, and there are some defenses in the case. So at this point, I just will maintain the not guilty plea and get with the state on this.
All right, so this will just be an arraignment,
Yes.
arraignment and a bond hearing, or there's already?
He's already on bond on this case, Judge, and the record hopefully reflects that. There's no kind of hold on him on this case. He's on bond on this case.
All right.
I want to make sure that is clear, right? The record is showing that he's on bond. There's not any kind of judicial hold or anything on him.
Let me call this case and let's double check. This is 20 CR 005982F, Reginald Kilgore. You're charged with one count of battery family violence. The offense date is October the 16th of 2020. State view, actually pre-trial. Ms. Harrison,
Good morning, Judge. I don't have that information.
you don't have that?
No, not bond information, no.
Hold on one second.
Thank you, Judge.
All right, I see that a bond was set by Judge Law, it's $4,000. The $4,000 good bond or surety bond?
Yes, and he posted that bond, Judge, back at the time of his release.
Okay,
He's in jail on a separate case, Judge, from
Gotcha.
got arrested March of this year.
okay, good. All right. So that at least tells us where we are at this point. Since we're going to just arraign him at pretrial, we don't need anything there. State, any announcement or anything?
Nothing from the state, Your Honor.
All right. Excuse me. All right, and counsel, do you want to waive the formal reading of the accusation or do you want it read?
Judge, we'll waive formal reading of the accusation, enter a plea of not guilty, and ask for 10 days to file any additional motion. The judge, if you could repeat that case number for the record for me, please.
All right, that case number is 20 CR 005982F is in front.
I have it. Thank you, Judge. That's all I have this morning then.
Hold on one second.
All right.
And that is Mr. Kilgore. Can you hear me?
Yes, ma'am.
All right, and your attorney has waived the formal reading of the accusation, but I just want to inform you that your case has been accused by the Solicitor General's office in Fulton County, and this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case is going to be reset for a jury trial. I will accept your not guilty entry here, and that the trial will be scheduled by the state court judge to whom this case is assigned. And again, at the jury trial, you have your right to an attorney, which you have. You do not have the burden to prove the charge at trial, but the state, represented by the Solicitor General, will bear that burden and will have to convince a jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, again, you could face a 1 year prison sentence or a fine of up to $1,000. And that could run concurrent or consecutive, but there's only one charge. But based on the information, how do you plead to this charge of battery family violence?
Not guilty.
I accept your plea of not guilty, and this case has been arraigned and reset for the notice for trial.
Thank you, Judge.
All right, thank you.
All right, is there any way I can go, is there a breakout room or speak on the phone to Mr. Kilgore? I think he's in Cobb County.
They will have to give you that number. We can't use up our breakout room for that. Do you all want to put that number in the chat that his attorney can call?
Ms. Taylor, call 404-612-2392.
2392. I got it. Thank you. I'll call him now. Thank you.
All right, thank
That's
you.
all
Have
I
a good
have,
one.
Judge. May we be excused?
Yes, you may. Thank you.
Thank you. I'll call the number now, Deputy.
Okay, he's by the phone. Position number 28, Your Honor, Mr. Shaw.
Okay. This is position 28, 22 CR 005967F. Salim Shah, you're charged with 1 count of criminal trespass and a 2nd count of willful obstruction of a law enforcement officer, both with the offense date of September the 2nd, 2022. And I have on the calendar your pro se. Is Mr. Shaw, are you representing yourself or is he represented by the PD's office?
Judge, when I went down to the jail to speak to Mr. Shaw, he informed me he did not want the services of the public defender's office and wanted to move forward pro se.
All right, Mr. Shaw, can you hear me?
Yeah. Yes, ma'am.
Okay, and Mr. Shaw, is it your intent to represent yourself today?
No. I ain't fully think that the people was ready for me to give me my services. You know what I'm saying? I was gonna give my service. I didn't really think they were ready. You know what I'm saying? I ain't have nothing to read. I have my eyeglasses. I wasn't fully paid attention to around here. Like I was, you know what I'm saying? Like I was standing tall, you know what I'm saying? Like I got like on my feet, you know what I'm saying? Got myself together. So, you know what I'm saying?
Well, my question to you now is a yes or no. If you want to proceed today, if you want to be
Yes, ma'am.
reset
Yes,
to
ma'am.
hire counsel,
Yes.
do you want to be reset to hire an attorney?
No, I'll go ahead with what's going on.
So now you understand, you have to know the rules and the laws in order to represent yourself. And if you don't, then that could be detrimental to you. Are you aware of that?
Yeah, they on my wrist right now. I mean, I got my handcuffs on. Yeah. I mean, well, I understand what you're saying. I ain't, you know what I'm saying, been down with you.
What is the disposition for this case? Is it ASG Reed?
Good morning, Your Honor.
Morning.
Our recommendation's 12 months, serve 36 days, credit for time served 18 days, balance probated, a stay away from the incident location, that's the Chevron gas station, and BHET.
Okay. All right. Pre-trial, I apologize. What do we have on Mr. Shaw? Our state, do you have,
I do. I have a little bit. He has a total of 46 cycles. We have a 2022 obstruction that's out of the city of Atlanta. I have a 2020 obstruction here. That's 21 SC 177611. A 2020 shoplifting, 2020 criminal trespass, 2019 criminal trespass, 2019 criminal trespass, disorderly conduct. Another case here in Fulton, 2019 is a criminal trespass, 19 CR 001076H. 2019 disorderly conduct, 2018 possession of drug-related objects, 2018 criminal trespass, but a 2015 terroristic threats criminal trespass, another Fulton County 2015 criminal trespass, that's 15 CR 004659. And then I just wrote down another 2014 criminal trespass, just to kind of give you an idea.
okay. Do you have anything major different, Ms. Harrison?
He's currently on probation for terroristic threats and obstruction of law enforcement officers under case 21 SC 177911. Sentenced June of 2021, 1 year confinement and 3 years probation.
Okay. All right, Mr. Shaw, are you interested in taking the offer? From
Well,
the city?
it's too, it's, if you was here listening, it's too much going on. Phone people on the phone, it's people behind, you know, too much going. I can't fully hear you. I ain't with your program. I'm listening to what you're saying on your program. What is the offer again? What is your offer?
The offer from the state again is 12 months to serve 36 days. You're getting credit for the 18 days. It's credit for time served. Is that correct, state?
Yes, that's correct, Your Honor.
So you're getting credit for your time served.
Okay,
When you get out, it will be, the balance will be probated. You're to stay away from the Chevron gas station, and they're ordering a evaluation as well, or requesting evaluation.
yeah.
So do you want to take that offer, or do you want to wait and consult an attorney, or what would you like to do?
Yes, take that off.
You would like to take that offer?
Yes, ma'am.
And so you understand there could be some consequences because you are already on probation for this new charge that you're entering, that it could affect that. So do you still want to take the offer?
Yes,
Okay, in order to take that offer, how will we get the plea work to the jail? Do you have that worked out so I can have that today?
Your Honor, if they can send me an email address, I can send it over to someone.
Okay, Deputy, who can we send the plea work to?
Your Honor, I'll just send an email.
I'm sorry?
I'll send an email to Ms. Reed.
Yes, okay.
She can send it. But I never knew that we had to do paperwork for SAPs.
Well, he's pro se. We normally do it, believe me, with all the pleas that we take. But generally, if they're represented by the PD's office, they send over the plea work.
Okay,
But since he's pro se, he's gonna have to fill it out himself.
okay.
Okay. And then we need to get it back today, or as early as we can,
Not a
before I
problem.
get off the bench. Thank you. All right, Mr. Shaw, I'm going to swear you in. Can you raise your right hand for me?
what she talking about, swear it in? I'm telling you, just said, man, I don't know what she talking about, swear me in to what?
I'm beginning to think that I'm not going to take this plea, so let's see what's going on. He's not clear about what he's doing.
I can't.
Your Honor, I'm,
Trying to play me, I can't read.
Your Honor.
Yes,
he wants to have the paperwork before he takes the plea.
That's what I don't go on, got fax machines, everything over here. I'm saying, I ain't confused and like I'm saying. It's just people, I ain't tired of you people. I don't even know you people. You know what I'm saying? I see what got going on around me. That ain't nothing. That ain't nothing.
Shaw, Mr. Shaw. The Solicitor General is going to email over the plea paperwork. We'll come back to you and you can look at it. But I'm
saying, I didn't know what was going on, so I'm saying, I will raise my hand. I'm having my hand raised right now.
I'm feeling that you're a little apprehensive or that you're not having a clear understanding of what you're getting ready to do to enter the plea. Although it's credit for time served, I don't know if you have other holds that may prevent you from being released because you are on probation. So do you want to freely and voluntarily enter this plea or not today is my question.
Yes, ma'am.
Are you sure?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give will be the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. I'm going to ask you a series of questions, which will also be some of the same questions that's on the plea paperwork that you will be filling out momentarily when it comes through the email. But I'm going to take this testimony from you at this point to be on the record, okay? And it's my understanding that you wish to plead guilty to 2 charges, one being criminal trespass and the second one being willful obstruction of a law enforcement officer. Is that correct?
Yes.
All right. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied? Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes.
That you're giving up or waiving your right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yeah.
And you're prepared and agreed to waive these rights today, is that correct?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty today?
No. No, ma'am.
Has anyone promised you anything to plead guilty today?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yeah.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
As to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, I'm going to accept your guilty plea with you representing yourself pro se. And again, explaining those conditions, you're to stay away from the Chevron. I don't have the exact address location. Do you
Judge,
have-
I have it, if you need it.
Yes,
Okay, it's 639 and it's Morogoso, Morosgo Drive, Northeast in Atlanta.
all right. Do you know where that is, Mr. Shaw?
Yes, ma'am.
Okay, you stay away from there, else you'll be right back down here in Fulton County Jail. Can you do that?
Yes, ma'am.
Okay, and also I'm ordering an evaluation, BHET, so they will come down and hopefully do that evaluation, obviously before you're released. So that's 12 months to serve, 36 days, credit for time served of 18 days, balance probated, and staying away from the Chevron and a behavioral health evaluation. All right.
All right.
All right. I will accept your plea. When that paperwork comes, they'll show you how to fill it out, and then they will send it back over to us. All right.
All right.
All right. Thank you.
Position 17.
This is 22 CR 006071Y. Demetric Joseph, is that you?
Yes.
Oh, I
Yes.
see. Okay, I was looking at the wrong screen. I apologize. And you're Mr. Joseph, correct?
Yes.
Okay, you're charged with one count of simple assault, second account of willful obstruction of a law enforcement officer with the offense date of August 30th, 2021. And what are we doing with this case today?
Yes, Judge. This is just going to be an arraignment.
Okay. All right, Mr. Joseph. Oh, let me ask you first, Mr. Finley. Do you waive a formal reading of the accusation?
I do.
All right. And Mr. Joseph, you have been charged with the two counts that I've read, simple assault and willful obstruction of a law enforcement officer. They have been formally accused by the Solicitor General's office of Fulton County. And each of these charges carries a maximum fine of $1,000 or a 12-month jail sentence for each charge. Each charge, they could run concurrent or consecutively. This case will be reset with the state court judge that is assigned to you for a jury trial, and they will further notice you for that. And at the trial, obviously, you have a right to an attorney. You have Mr. Finley at this point. You do not have the burden to prove the charges at trial. The state, represented by the Solicitor General's office, will bear that burden and will have to convince a jury beyond a reasonable doubt in order to get a conviction in this case. If they do not get a conviction, you can face a sentence or up to, if they do get a conviction, I'm sorry, you can face a sentence of up to 1 year in prison or a fine of $1,000 for each of these charges. Based on this information, how do you plead to the charge of simple assault?
Not guilty.
How do you plead to the charge of willful obstruction of a law enforcement officer?
Not guilty.
All right, I will accept your plea of not guilty. This case has been arraigned and it will be reset for the notice for trial, okay?
Thank you.
All right, you're welcome.
Position 1 in medical.
Okay.
And
I'm sorry,
Judge,
what was that name?
What's the name? of that
Allen. Okay.
Okay, thank you. This is 22 CR 005950Y, Dexter Allen. You're charged with one count of theft by shoplifting. The offense date is September the 3rd, 2022. What's the announcement on this case?
this will be an arraignment, Judge.
Okay, Mr. Finley. All right, Mr. Allen, can you hear me?
Yes, ma'am.
Okay, and again, I just read your charge is theft by shoplifting. You've been, do you waive the reading of the accusation, Mr. Finley?
I do, Judge.
All right, you've been formally charged by the Solicitor General's office with this charge, and it carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case will be reset for a jury trial. The trial will be scheduled by the state court judge to whom this case is assigned as further notice for trial. At the jury trial, you have a right to an attorney. You do not have the burden to prove this charge at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, again, you could face a sentence of up to 1 year in prison or a fine of $1,000. Based on this information, how do you plead to the charge of theft by shoplifting?
Not guilty.
All right, I will accept your plea of not guilty. This case will be reset for the notice for trial. All right. Thank you. And let's see, who do we have next?
Yep, Your Honor, we have Mr. Gregory, Lamar Gregory.
Okay.
Good morning, Your Honor. This is Attorney Sterling Stephenson. I'm representing Mr. Lamar.
Okay. Hold on.
For the
Hold on 1 second for me.
Absolutely.
He's position 19, Your Honor.
So this is Mr. Lamar. All right, this is case number 21 CR 005470F. Mr. Gregory Bernard Lamar, you're charged with 1 count of battery family violence. The offense date is October the 12th, 2021. And I see private counsel, Mr. Stephenson.
That is correct, Your Honor.
All right, Mr. Stephenson, what is your announcement for today?
Your Honor, for the purposes of arraignment, we'll be pleading not guilty. We're waiving arraignment, pleading not guilty. Your Honor, he was picked up on a failure to appear. The reason why he missed the court notice was due to the fact that he lost everything in a house fire. He was not at that residence when the notice was sent. That's why the bench warrant was issued. That's why we are in the position that we are in today. He does have a surety bond in place. However, he doesn't have any means of covering it. We are respectfully asking the court for a signature bond. He was picked up on September 2nd. He has served 22 days up until today. And we're hoping to get him out. There are people that he works with. He handles taxes for that that need his assistance ASAP. And for those reasons, we would respectfully ask the court to allow him to sign off on a signature bond for his release.
How old is Mr. Lamar?
Pardon me, Your Honor?
What is the age for Mr. Lamar?
He's either 63 or 64. Mr. Lamar, can you hear me?
Think he's on mute.
Yeah, I believe he's on mute. Yeah. It's either 63 or 64, Your Honor.
Okay, that's fine. And you said that he's working?
Yes, Your Honor.
And it looks like he was out on a $3,000 signature bond through pretrial from October of last year.
That is correct, Your Honor. From what I understand, he's had to move twice within the last year, once due to a fire, and then he also moved again. He was under the impression that this case was dismissed. And when I spoke with him earlier, all of this kind of caught him off guard. And he was not represented by counsel from the get-go. He is now. And I have filed my entry. I did file my discovery demand. And there will not be any future FTAs, Your Honor. He's not a threat to anybody. He's been a standout member of society for 63, 64 years. And we would respectfully request a signature bond under these circumstances.
And Your Honor, obviously we won't be objecting to the signature bond. As you know, he already had a signature bond. Not only did he have a signature bond, he was on pretrial services. As you know, when you're on pretrial services, you have to report monthly. So I'm so sorry that his house burned down and that he had to move twice, but I have no idea how he could have thought his case was dismissed, because if he were reported to pretrial services as required, he would know the status of his case and he would probably know his upcoming court date. So with that being said, that really has nothing to do with the cost of tea in China. We object to the signature bond, and we ask that the bond that's set in place by Judge Richardson is maintained and stays in place. There's absolutely no reason. Now, if it was a SOB jail, maybe you can get the benefit of the doubt, but even under those circumstances, we all know, condition of your bond is to keep the clerk of court up to date with your most recent address, or whether you have an address or not. But in this situation, he was required to report to pretrial. I'm not sure how you're reporting to pretrial and you're not aware that your case is still ongoing. So with that being said, we're asking that the bond is maintained. And we haven't got into its history. I mean,
Now, I have the, you said a bond by Richardson. I'm looking at the bond by Morrow.
I think when, Your
I
Honor, if
think
I
the
can't,
bench warrant was issued by Richardson, so I might have.
Okay, okay. I was making sure there was not any additional information that I was missing. Because I had that $3,000 SOB pretrial in October of last year by Judge Morrow.
Right, and then he went to Richardson and then he bench warranted. So I think that was the bond that I was referring to.
that's right. They
Okay.
tend to just double the bond amount, Your Honor, on the divisions when they miss court, but
And typically when someone's picked up on a bench warrant and there is a bond amount set by the division judge, we send them back to the division judge anyway. So we would just ask that this case is treated the same. And if it was SOB jail, maybe I would feel differently, but people get the benefit of signature bonds via pretrial services for a reason. There's certain requirements. Obviously, those requirements were not met because here we are on a bench warrant and he didn't even know his case was still open. So
Your Honor, if I completely forgot to add a very vital bit of information. He has serious health issues. He has diabetes. He recently just had a stroke. He has high blood pressure, chronic pulmonary artery disease. These are all serious medical issues that he is currently dealing with, and he has not been getting the medication in jail. The quickest way for him to get out would be a signature bond. And yeah, I can't speak to what happened before last week because I was just retained last week. However, he does have private counsel. There won't be any FTAs in the future. And being in jail any longer is a grave risk to his health, especially. I don't know what the current situation is with COVID down at the jail, but I was aware that it was running rampant. And he does have serious pre-existing health conditions, and he really needs to get out ASAP.
Mr. Walker, I'm going to ask pretrial real quick, just a quick summary on his criminal history, but I do now have the February 18th bond with Richardson for the 6,000 surety. So I have that now.
okay, thank you.
How many cycles pretrial?
He has 24 cycles, but prior to this judge, he was not in compliance with pretrial.
Right, okay.
And that was part of my whole argument. So 24 cycles, you're not any stranger to the criminal justice system. You got the benefit of a pretrial signature bond. You're not being compliant. You're not reporting to your appointments. You're not keeping the clerk up to date with your address. I don't want to misquote, but is this a battery case or?
Yeah, it's a battery.
Yeah.
Battery family violence.
I think I've kind of belabored the point, if you will. So I think the court is aware of the state's position.
Correct. I'm going to continue to enforce the $6,000 surety bond entered by Judge Richardson. I can arraign the case if it has not already been arraigned. But I'm certainly not going to, based on his history and the information that I have, I will not convert that to a signature bond at all. But it is a $6,000 surety bond that still exists. Does he need to be arraigned?
The state will request that he is arraigned, Your Honor, while he's in custody.
Okay,
Or he could file, I don't know if council wants to waive arraignment, is whatever his pleasure is.
We would like to waive arraignment, Your Honor.
okay,
And when we waive, that means you have to file a formal waiver. Just a heads up.
I can e-file that as soon as I'm excused.
okay. Yeah, please make sure you do that. And is there anything else that we need to take up?
Just want to make sure the
no.
conditions on this bond are the same, the stay away and no further contact.
Okay, so bond conditions are still there as previously ordered. Nothing has changed.
Right.
Thank you. All right, if that is it, then Mr. Stephenson, you are free to go.
Put your hand up. You can sit down. Yeah,
Thank you very much, Your Honor.
I think he's trying to say something.
It should be very limited. He's got to listen to his attorney. You have a question about your bond?
Yeah.
No, I had a statement to make if I could, Your Honor.
It better only be a question about your bond or the conditions, because this is not your trial, and I suggest that your attorney's gonna tell you to not make any statements against your interest. Do you have a question?
Is there any way that my bond can be lower, Your Honor?
No, I just said that. No, based on your history, based on your FTA, failure to keep up with pretrial. And I don't see a reason why, even though you may have had some housing issues, you could not have gotten in contact with someone so that you didn't miss your court date. Sympathize with your health issues, and hopefully your attorney can speak with the jail and make sure that you start to get your medication. But it is a $6,000 surety bond in place. And I'm going to
Say
continue.
I was never notified by pretrial. I never had any information from pretrial to report to.
When you were released previously, you would have been given that information.
I was not, though, Your Honor.
Not for sure that I am convinced of that.
I apologize, Your Honor. Mr. Lamar, we'll pick this up as soon as we get you out. I need to file the waiver of arraignment, and we need to set up means to post the surety bond, and we'll pick up this discussion when you're out, okay?
All right.
All right, thank you.
We didn't know.
May I be excused, Your Honor?
Yes, you may. Thank you, Mr. Stephenson.
Thank you. Have a good day.
You too.
Position 7, medical.
Okay. This is 22 CR 006012J, Sanford Butler. You're charged with simple battery, family violence. The offense date is 9/5/2022. And what this is a non-negotiated plea.
That's correct, Judge. This is a non-negotiated plea with the no further contact at issue.
Okay. State. Ms.
Yes,
King.
Your Honor. Yes, good morning, Your Honor.
Good
The
morning.
offer is 12 months to serve 30 days, credit for time served 15 days, ADET, a stay away and no further contact. The state is requesting the stay away after speaking with our victim in this case. She stated that they are married, live together, but share no children. She stated this is not the first time the defendant has been violent with her, and she has called the police on him in the past. The victim also stated that this is the second time they have been married, and she thought this time would be different, but the same cycle is repeating, Your Honor. The victim states that she fears how the defendant will act once he's released, and she has filed for a TPO. We have not gotten back in contact with her to see the status of that TPO as of this morning. The victim is asking for no contact and for him to stay away, but she is okay with the one-time law enforcement escort to retrieve his belongings. This incident occurred on September 5th of this year. The victim in this case, Kimberly Butler, called the police due to a domestic disturbance, and she said her husband battered her in the home. And as I stated before, this is not the first time that this has happened. For that reason, Your Honor, the state feels that the stay away and no further contact is more than appropriate. He's asking the court to honor the victim's wishes in this case.
And Judge, so we're asking for no further violent contact just because I spoke to his wife last night. And she made very clear she did want contact with him. She did not want them to live together. So the stay away would be in place. So she wants them to live separately, but she asked if no further violent contact would be possible. And I said yes. So I'm just reporting what she told me, and I'm asking for what she wanted me to ask for, and that is for no further violent contact. But once again, she did say she wanted them to live separately, but did want to have contact, and she did want, if possible, him to have a one-time escort to get his belongings at their home. But like Ms. HG said, they are a married, Judge. They do have children, both from previous relationships that they co-parent and help raise each other's children. But yeah, Judge is asking for that no further violent contact, and also that the probation fees could be waived for Mr. Butler.
Your Honor, if I may, the facts of this case is very alarming. The actual simple battery that occurred in front of the officers, Your Honor, which shows the state that he has no regard for the law. He honestly doesn't care, Your Honor. So if he's willing to slap glasses out of her hand in front of the officers, imagine what he would do without officers present, Your Honor. And for that reason, we're renewing our objection to the contact and as well as the stay away. We're concerned for the safety of Ms. Butler, especially since this is their second time trying it again and the same cycle is repeating.
Okay.
And obviously, if the victim is not here, I don't have any reason not to believe PD Finley, but if the victim is not here to state that for herself, I would just reiterate what Ms. King said or just stated.
Thank you. Mr. Finley, if I'm inclined to accept the plea, I would order that there be no further contact. They're not living together and don't have any children together. I don't particularly see a reason that they need to have any contact. But to make sure that he completes his probation and completes that successfully. And hopefully that will give them time to decide what happens with the marriage or the relationship. So I would order no further contact. So,
Understood, Judge. Mr. Butler. Yes, Judge. Mr. Butler, do you still want to move forward with the plea, sir?
Can you please restate everything that's
so
what's different? What is different from what we discussed yesterday?
So from what we discussed, Mr. Butler, there would be a no further contact between you and your wife, and a stay away. So you guys would not be living together. You could have a one-time escort to go get your belongings, but you two would not be living together. That is if you took the plea, sir.
That's fine.
Okay. All right. So we'll move forward, Judge.
okay. All right, Mr. Butler, we're going to start with your plea. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, Mr. Finley, you stipulate the venue, identity, and factual basis.
I do, Your Honor.
All right. In order to take your plea, Mr. Butler, I'm gonna have to ask you a series of questions. It's my understanding that you wish to plead guilty to one count of simple battery family violence. Is that correct?
Yes, it is.
All right. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am, I'm not.
Are you satisfied with the services and representation of your attorney?
Yes, I am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am, I do.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am, I do.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
Do you offer this guilty plea freely, voluntarily, with the full understanding of the charges against you?
Yes, ma'am.
And again, as to the charge of simple battery family violence, how do you plead?
I plead guilty.
All right, I would accept your plea. And again, those conditions are 12 months to serve 30 days, credit for time served at 15 days. You are to get an ADET, which Mr. Finley will explain to you, following your recommendations for that evaluation. And you are to stay away from the incident location, which I assume is the marital residence. I don't have that in front of me, and you to have no further contact with Kimberly Butler. What is that address?
My apologies, Your Honor. It's 822 Ashley Lane.
Okay.
And the victim's name is Kimberly Butler, Kimberlee. Last name is defendant.
All right. And again, you are to stay away from that address while you're on probation. And you are to have no further contact while you're on probation with Ms. Kimberly Butler. I will waive 6 months of your probation fees. And I think that is all that we need to take up. Anything else, counsel?
Nothing from the state.
Okay.
Nothing further, Judge.
All right. Thank you.
All right, position 4 next.
And Judge, this will be an arraignment.
Okay. All right, this is case number 22 CR 0052223D. And I think it's Everiel, and I apologize if I'm mispronouncing it, Billings. You're charged with 1 count of possession and use of drug-related objects, giving a false name, address, or birth date to law enforcement, both with the offense date of August the 5th, 2022. And again, I understand that this is going to be just an arraignment. And again, Mr. Finley, do you waive a formal reading of the accusation?
I do.
All right. Mr. Billings, and I think you're there with the glasses, correct, Mr. Billings?
Yes, ma'am.
Okay. Making sure I had the right screen. All right, Mr. Billings, again, excuse me, you have been formally accused by the Solicitor General's Office of Fulton County of the charge of possession and use of drug-related objects and giving a false name, address, or birth date to law enforcement. Each charge carries a maximum fine of $1,000 or a maximum sentence of 1 year in jail. This case will be reset for a jury trial. The trial will be rescheduled by the state court judge with whom this case is assigned as further notice for trial. As to the jury trial, you will have the right to an attorney at that time. You do not have the burden to prove the charge at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face again a sentence of up to 1 year in prison or a fine of $1,000 for each of the charges that could run currently or consecutively. Based on this information, how do you plead to each of those charges?
Ma'am, yes, ma'am.
How do you plead to the charge of possession of and use of drug-related objects?
Not guilty.
How do you plead to the charge of giving a false name, address, or birth date to law enforcement officer?
Not guilty.
All right, I will accept your not guilty plea, and this case will be further reset for trial.
Yes, ma'am.
All right, thank you. That will conclude
All
your
right.
case. All right, thank you.
Your Honor, you got position number 8, Mr. Cantrell, position number 8.
And this will be a negotiated plea, Judge.
All right. This is case number 22 CR 006010C. Rashad Cantrell, you're charged with 1 count of criminal trespass, the 2nd count of possession and use of drug-related objects, both with the offense date of September the 6th, 2022. All right, State, Ms. King.
Yes, Your Honor. The offer is 12 months to serve 28 days, credit for time served 14 days with the balance probated, a ADET, and a stay away from 226 Ralph David Abernathy Boulevard Southwest. That is a Family Dollar location.
Okay. All right, is that your understanding, Mr. Finley, of the plea?
Yes, Judge, that is my understanding of the plea, of which we do agree. I would just ask that once Mr. Cantrell does complete the ADET, if the balance of his probation could be suspended, as that's the only thing, other than the stay away, that's the only thing the state is asking him to do is that ADET. So just asking once again for that balance to be suspended once he completes that, Judge.
All right, any objection by the state?
No, Your Honor, due to the defendant's limited criminal history.
Okay. All right, Mr. Cantrell, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, I've got to ask you a series of questions in order to take your plea. Mr. Finley, do you stipulate the venue, identity, and a factual basis?
I do, Judge.
All right, and again, Mr. Cantrell, I understand that you wish to plead guilty to the 2 charges, is that correct?
Yes, ma'am.
All right, are you currently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're waiving and giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to remain silent? Giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
And again, has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and again, as to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of possession and use of drug-related objects, how do you plead?
Guilty.
All right, and again, you understand the conditions of your plea.
Yes, ma'am.
All right, again, it's 12 months to serve 28 days, credit for time served at 14 days. The balance will be suspended once you have completed the ADET, the evaluation. And during the time that you are on probation, you are to stay away from the Family Dollar at 226 Ralph David Abernathy Boulevard. You understand that you must do that?
Yes, ma'am.
All right. Good luck to you. Is there anything else I need to take up, counsel?
Nothing further.
Nothing from the state.
All right, your plea has been accepted. Thank you.
Your Honor, can we do the Spanish interpreter case? I see it on there.
Okay,
Ms. Blunt.
I think I saw her on the screen.
Good morning, Your Honor. This is Adriana Chianci, court interpreter.
Good morning, how are you?
I'm doing very well, thank you.
Good. Which position is this, deputy?
It's 21, Judge.
21? Thank you.
And I'll need a breakout room to speak to Mr. Augusto with the Spanish interpreter, Judge.
Oh, you need to do that first?
Yes, Judge.
Okay. Ms. Champion, you put them in the breakout room, deputy. We may need to go to another case. They need to talk in the breakout first with the Spanish interpreter.
Can we do probation one, Mr. Spencer?
We can.
And Judge, that's my case, so we can do that.
Oh, wait a minute. Ms. Helen needs to go into the breakout, but she also has this case. I prefer maybe, can she go into the breakout first and we do another case? Because this is also her case.
Okay, I mean, we can go to Mr. Jerome Foley. I believe that's Zach.
Okay. Okay.
What is the name and position?
Which courtroom needs to be in a breakout with Miss Helen?
Ms. Helen, the Spanish interpreter, and is that courtroom 2?
Your Honor, if we could, Miss Helen, can you guys do a three-way on the phone with the Spanish interpreter, you and Mr. Martinez, and that way we can still do Mr. Foley in the courtroom so we won't interrupt court at all?
Sure, Madam
Done it
Interpreter,
before.
are you
We've done
used
it
to doing a
before.
three-way? Have you done that with the Spanish interpretation before?
I believe I have. I'm not
Yeah.
sure what you mean. It's like going into a courtroom with you, virtual room.
Telephone, on the telephone, just a regular.
Oh, yes,
Yeah,
of
like a
course. I
conference
use,
on the telephone, that's all it is.
yes. Do you need my phone number?
No, just call 404-612-2392. Mr. Martinez will pick up the phone and then you can call Ms. Helen. She can give you her number and we can take care of.
Let me make sure,
one
please.
song.
Let me make sure it's 404-612-2312.
No, 2392.
92. All right, I'm calling right now, sir.
Okay, Mr. Martinez, siéntase.
Thank you.
Muchas gracias. And now we can go to Mr. Foley.
Okay. This is 19 CR 002187C, Jerome Farley. You are charged with 1 count of simple battery family violence with the offense date of April 3rd, 2018. And this is a plea.
That's correct, Judge. Negotiated plea.
All right. State.
Yes, Your Honor. The offer is 12 months to serve, 28 days, credit for time served, 14 days, FVIP, no further contact, and a stay away. The no further contact is with Ashley Wharton. First name traditional spelling, last name WHARTON, and the stay away is from 4000 Jeffrey Trail in Atlanta.
And that is our understanding of the offer, Judge, of which we do agree, and do stipulate that the factual basis, venue and ID, would just ask that the probation fees could be waived for Mr. Farley.
Okay. All right, Mr. Farley, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? Okay, you can put your hand down. I'm going to ask you a series of questions in order to accept your plea. And the first one being as to the charge of simple battery, family violence, you want to plead guilty, is that correct?
Yes, ma'am.
All right. And again, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up and waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agreed to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right. I'll accept your guilty plea. And you understand the conditions of your plea, is that correct?
Yes, ma'am.
You are to stay away from 4,000 Jeffrey Trail, and you'd have no further contact with Ashley Wharton. You understand that?
Yes, ma'am.
And you're to take the FVIP class, which I believe is at 24 weeks.
It is, Your Honor.
24 weeks. Once you get started, you stay with it, or else you'll have to start all over again. And again, the no further contact and the stay away. I will waive 6 months of your probation fees to help you out a little bit. And that should conclude this case.
Can I ask you a question?
Is it about your bond? I'm sorry, about your plea? Are the conditions?
Something similar to that. It's about my probation. I'm on probation, but this case happened way before I got on probation.
Okay, ask Mr. Finley to clarify that for you as your attorney. And I don't know if there's anything you need to talk about, or is it okay with the plea? What do you say, Mr. Finley?
If I could speak to him briefly, I'll give the court a call if I can.
I think they're on the, I think the interpreter, they're on the phone, are they not?
Okay. If
Hey,
you
Zach, call the 911 number. Call my number.
okay, I will. All right, thank you.
Come on.
Okay. Yes. Jeffrey Trail. Mhm. Okay, Mr. Finley,
Yes, Judge.
are we fine with the plea on Mr. Farley?
Yes, yes, we are.
Okay, all right. Thank you. Who do we have next, Deputy?
Your Honor, I believe the two cases that I have here in the courtroom are for Ms. Helen.
Oh, okay.
And she's
I
on the
see. It
phone.
looks like they're still on the phone.
Yeah. Lo que quiero preguntarle, lo que sí,
While we're waiting, may I get clarification on the announcement for position? It says 14-15. Those are two different people, I believe, according to the calendar, but 13 and 14 is the same. So are things supposed to be moved up one?
Yeah.
I
So,
have 14 and 15 as the same person as
yeah,
well.
so what you're looking at, Ms. King, that was the old calendar that was 38 positions. So the newer one was 36. Yeah, so the
So Mr.
I have-
Gooden.
Yeah,
is, I
14 and
believe-
15. 14 and 15 is Carlton Hall.
right.
Oh, okay.
Okay. And then 16 is Lloyd Hewley.
Got it. Thank you so much for that clarification.
No, no problem. Yeah. Don't have that many, please. Nope. Deputy, is there any way to do position 13, I believe is Mr. Finley's case?
Yeah, I don't have 13 in the courtroom.
Oh, okay. No worries.
The only positions I have is Mr. Wilson and Mr. West, which is position 36. And also position 32 and 33. Mr. West is 32 and 33. Mr. Wilson is 36.
And Judge, those are all my cases.
Okay.
And Your Honor, if I can ask the deputy something, we have Larry Brown on today's calendar.
Yeah,
At one
he's
point-
here right now. That's what I was talking to, Mr. Walker.
Okay. He has a
called his
private
attorney.
attorney.
He did call Isaiah Gregory. He's supposed to log on.
Correct. That's why I was asking.
And he didn't log on as of
Oh.
yet. Oh, there he is.
Speak
There
up,
we go.
speak up.
There
All right,
we go.
thank you, deputy.
All right, you're welcome. My man, one second. I want to help so many people, man. My man.
Mr. Gregory, good morning. Can you hear me, Attorney Gregory? Don't think so.
Yes, Your Honor. I'm sorry, I had the microphone muted.
Okay. Good morning. How are you?
I'm doing pretty good, Your Honor.
Good. You're here for, is that position 6? Larry Brown is your client?
Yes, Your Honor.
All right, we're ready to proceed on 6.
State's ready, Your Honor.
All right.
It's ready. Defense ready, Your Honor.
Okay, 21 CR 0003110Y. Larry Brown, is that you at the courtroom too, Mr. Brown?
Yes, ma'am, it is.
Okay, you're charged with 1 count of simple battery, family violence. The offense date is July 13th, 2020. And I understand this is going to be a time served plea.
That's correct, Your Honor.
That's correct, Your Honor.
Okay. And no conditions, no bond, correct?
That's correct, Your Honor.
All right. Mr. Brown, can you raise your right hand for me?
Yes, ma'am.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. And Mr. Brown, I understand that you want to plead guilty to the charge of simple battery, family violence with a time served plea.
Yes, ma'am.
All right, I'm going to ask you a few questions. You can put your hand down
Yes.
to make sure that you understand your plea. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am, I'm not.
Are you satisfied with the services and representation of your attorney?
Yes, I am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And again, as to the charge of simple battery, family violence, how do you plead?
Guilty.
All right. And Mr. Gregory, are you prepared to send me over the plea paperwork today?
Yes, Your Honor. I'll do it right after this proceeding.
Okay. And again, Mr. Brown, you understand this is a time served plea for 365 days, and that will complete this case. You understand that? I don't know if you heard me. Mr. Brown, do you understand this is a time served plea for 365 days, and that will conclude this case?
Yes, ma'am.
Okay.
And then, Your Honor, if I can inquire, does Mr. Gregory need Miss Grace's email?
Yes, it's at you can provide that in the chat.
1 second.
Thank you, Mr. Walker.
And Your Honor, we're ready on position 21 whenever you're ready.
Okay.
All right, Your Honor, I received the email and we're ready to proceed.
And all right, I believe this will conclude. Is there anything else that we need to take up with Mr. Brown?
Nothing from the state.
Nothing further from the defense, Your Honor.
All right, Ms. Grace is putting her information in the chat as we speak.
Oh, I already sent it over, Ms. Grace.
Thank you. Thank you,
I
Mr.
sent
Wade.
over your information, that is, not the paperwork. Let me clarify.
Appreciate that.
All right, Your Honor, and it appears to conclude all my pending matters before this court today. May I be excused?
Yes, you may. Make sure I get that paperwork, Mr. Gregory. You just don't know how many times we're waiting till 6 o'clock from private counsel. So don't let us talk about you, okay?
Yeah, I'm going to sit it now.
Okay, thank you. Appreciate
Thanks,
it.
Mr. Your Honor.
All right, Mr. Brown, that concludes this matter. Good luck to you.
Thank you, ma'am.
All right. And I think, Deputy, we're ready to go back to 21.
Yes, Judge.
Oh, all right, that's not in courtroom 2, that's the other screen, correct?
No, I think Mr. Martinez is in courtroom 2.
CN2? Okay.
Mr. Martinez, Your Honor.
Okay. All right, thank you. This is case number 22 CR 005970H, Augusto Martinez. You're charged with 1 count of XB, and the offense date is 9/3/2022. Are we able to discuss this comfortably on this format, or do we need to conduct this in a breakout?
I don't mind the breakout session, Judge.
I'm not
We can
sure what the facts are, but I usually do not discuss this in open court.
And Your Honor, the victim is on the line if she could attend the breakout as well, so she could speak to Your Honor.
Okay. Let me do this. Let me swear in our interpreter first. Madam Interpreter, is this English to Spanish?
In Spanish to English, yes.
Okay. Do you solemnly swear or affirm that you will faithfully interpret from Spanish to English and English to Spanish the proceedings before this court in an accurate manner to the best of your skill and knowledge with no embellishments?
Yes, Your Honor, I do.
All right, thank you. Ms. Helen, I'm making sure I'm doing this as comfortably as possible. So be yourself. I don't know, technically, do I need the interpreter? I guess I will and won't in my breakout with ASG Reed, yourself, and the victim. What's the victim's name?
It's Ashanti Carter, and then also Ian Walker. We need to go to the breakout.
Okay. Bless you. All right, Ms. Carter, can you turn on your camera for me? Do you wish to address the court today?
Yes.
All right, is this going to be a plea?
It's going to be a non-negotiated plea, Judge.
Okay. Let me do this. Ms. Champion?
Chancy, is that me?
No, Ms. Champion is my Zoom.
Okay.
Can you hear me, Ms. Champion?
Yes, ma'am.
If Ms. Helen, Mr. Walker, and Ms. Reed, if we go into breakout? Can you add Ms. Carter? I want to talk to them first, or do you have to do that all at one time?
I can add her.
Okay, let us go in and then and don't add my victim just yet. Let me talk to the attorneys first.
Okay.
Okay. And hold on a second for me, Ms. Carter. All right, pretrial. Pretrial.
Yes, Judge.
On position 21, Mr. Martinez. What do you have on him?
I have 3 cycles. One is in Florida, and that was just alien removal. And 2 cycles in Georgia.
And what were those?
2020 criminal trespass from Martyr PD. And a disorderly conduct that was no pros.
Okay. All right, Mr. Walker, any other thoughts?
I'm looking into something, but if you want to begin with the plea, you can, and I will report back if I have anything that I think the court should know. But obviously, when I hear the criminal trespass from Martyr PD,
I think we're thinking alike. I don't know if that's good or
I was
bad.
about to look up the
I do
disorderly
have
conduct because I'm curious. I understand it was null pros, but I'm curious where that disorderly conduct took place. But with me hearing a criminal trespass from Martyr PD, and this is his second Martyr incident, perhaps a Martyr stay away is appropriate. Is where I was going.
Judge, we're gonna go ahead and say that would be extreme for like a all Martyr. We're gonna go with the time served that we were negotiating, Judge, with the SDET class, with the reporting judge, and we're asking for those probation fees to be waived. He's had 3 cycles, no repeat of this kind of crime, or apparently any other aggressive crime. But if you would like to do the research into the criminal trespass and null pros disorderly, go ahead, Your Honor.
I'm curious about the one with Marta as well. If Mr. Walker is able to.
I'm
find
trying to
that,
pull up in Odyssey.
just to make sure it's nothing that is remotely related with his writing Marta. I do want to make sure that other Marta customers are safe if this is. And I think pretrial said it was 2020 with the Marta trespass. Is that correct? Yes, at 2020. So it's not too far back, a couple of years.
Okay, if I could just have 1 second, I'm trying to
Okay.
go back and forth in between screens and. One second, I'm sorry, Judge. He's not coming up by name, so I'm gonna have to search by case number. Hold on.
You know, either. Huh. Ms. Gracie is looking with you as well, Mr. Walker. She's not,
And I'm looking as well.
everybody's looking, we're not finding anything.
Oh, I'm about to find.
Found over, okay.
Hold on.
You know, the other Marta incident may have been in DeKalb, so that could be why he's not finding it.
Oh, it was DeKalb and not Fulton, okay.
When I look at his criminal history, that's what I see.
And that's all it says.
And then.
I'm sorry, that Marta case is out of DeKalb. And it's showing that it was dismissed.
Okay. Okay. Mr. Walker, since it's DeKalb, I will, and Miss Helen, Miss Reed. Miss Helen, can you ask, Mr. Martinez, I guess it's Marta, his only mode of transportation?
Madam Interpreter. can you
Yes.
ask Mr. Martinez,
Señor Martinez,
if Marta is his only mode of
his
transportation.
microphone needs to be turned on.
Oh, okay. There we
Señor
go.
Martínez, Marta es el único transporte que puede usar usted.
El Marta es el único medio de transporte que he usado durante 15 años.
It's the only transportation means I have used for 15 years.
Yes, Judge, that is his only means of transportation.
Y ese es su único transporte.
Ese es mi único medio de transporte. Otra gente latina, ellos se recogen entre sí en carro, pero yo no tengo amigos de carro, tengo que transportarme en bus y tren.
I can only use bus or train. Other Latin people give each other rides, but I cannot transport myself that way.
I think in speaking with my victim, and I asked her briefly about that, Mr. Walker, I think she's okay with it, feels safe because it's not something that she uses every day.
Yeah, as long as the court just makes it clear that if he should see the victim, that he's to
Right.
stay away and he's to turn around and wait for the next bus or train, if you will.
Okay, right. Yeah, I will not do the stay away at this time and of course instruct the victim. I'm sorry, instruct the defendant with the interpreter in a second as to what I'll tell him about his conditions, okay?
Okay, thank you, Your Honor.
Okay, thank you. All right, again, this is case number 22 CR 0059708.
De nuevo, este es el caso 22 CR 005970H.
And this is going to be the non-negotiated plea for Mr. Augusto Martinez.
Y este va a ser el convenio declaratorio no negociado para el señor Augusto Martínez.
And we're ready to take the plea. Is that correct, Ms. Helen?
Estamos listos para tomar la declaración, ¿correcto, señorita Helen?
Yes, Judge.
Sí, su señoría.
All right. Do you stipulate to the venue, identity, and factual basis?
¿Usted está de acuerdo con la base de lo fáctica de los hechos?
Yes, Judge.
Sí, su señoría.
All right. Mr. Martinez, I need to ask you a series of questions before I accept your plea, okay?
Antes de tomarle su declaración, señor Martínez, yo necesito hacerle una serie de preguntas. ¿Está de acuerdo?
Estoy de acuerdo.
That's all right.
All right, I need to swear you in.
Necesito juramentarlo. Levanta su mano derecha.
Can you raise your right hand?
Ujú.
Do you affirm that the testimony that you're about to give
¿Usted afirma que la declaración que va a dar
will be the truth and the whole truth?
será la verdad y toda la verdad?
Yo digo la verdad.
under the penalty of perjury.
bajo so pena de perjurio.
This is the courtroom. This is the courtroom.
Lo jura?
Lo juro.
I do.
All right. Are you under the influence of any medication, drugs, or alcohol at this time?
¿Está bajo la influencia de medicamentos, drogas o alcohol en este momento?
Sí, hace cierto tiempo estoy con el Grady con medicamentos.
I have been taking medication prescribed at Grady's. ¿Puede bajar su mano, señor?
Okay, that's okay. It is prescribed to you.
O sea, es recetada.
He recetado todo por el Grady, por stroke, por mi sangre, bajo presión sanguínea, todo, un montón de enfermedades.
Yes, it has been prescribed at Grady due to stroke, blood pressure problems, blood circulation problems.
But it does not affect his ability to comprehend and understand this plea. Is that correct?
Pero esos medicamentos no le afectan su capacidad para entender lo que está pasando ahora, ¿cierto?
No me afectan, no consumo drogas.
They don't affect me. I don't use drugs.
All right. Are you satisfied with the services and representation of your attorney?
¿Está usted satisfecho con la representación y el consejo de la abogada?
Yo estoy consejo con la abogada.
I am satisfied with her advice.
Do you understand that by pleading guilty, you're giving up or waiving the rights?
Usted entiende que al declararse culpable usted renuncia a su derecho de ir a juicio con su caso, ¿entiende?
Entiendo.
I do.
The rights to the presumption of innocence?
El que se lo presuma inocente si va a juicio, ¿entiende?
Entiendo.
I do.
The rights to remain silent and not testify against yourself?
El derecho a guardar silencio y no declarar en su contra en un juicio, ¿entiende?
Entiendo.
I do.
The right to a trial by judge or jury, whichever you prefer?
A tener un juicio ante un jurado o ante un juez, el que usted prefiera si va a juicio, ¿entiende?
Entiendo.
I do.
Are you prepared and agree to waive these rights today?
¿Está preparado entonces para estar de acuerdo y para acordar a renunciar a este derecho de ir a juicio con su caso?
Entiendo.
I do understand.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
¿Hay alguien que le haya dicho que usted iba a recibir un dictamen o sentencia menor de la que va a recibir si se declara culpable?
La verdad, no.
To tell you the truth, no, I haven't.
Has anyone promised you anything to plead guilty?
¿Hay alguien que le haya prometido algo especial para hacer lo que usted se declare culpable?
No.
No.
Do you understand that if you're currently on probation, your probation may be revoked because of a guilty plea today?
¿Usted entiende que si está cumpliendo una pena de probatorio, libertad condicional en otro lado, esta declaración de culpabilidad puede hacer que esa libertad condicional que usted podría tener se cancele? ¿Entiende?
Entiendo.
I understand.
And do you offer this guilty plea freely and voluntarily?
¿Y
with
usted,
the- Go ahead.
¿Y usted se está declarando culpable libre y voluntariamente?
With the full understanding of the charge against you?
Con total entendimiento del cargo que tiene en su contra.
Con total entendimiento.
With total understanding.
With the charge, as to the charge of SB, how do you plead? And I'm giving those initials only because I don't want to state the charge.
Y por el cargo de SB, y le doy las iniciales en inglés porque no quiero dar la explicación ante el público de lo que es ese cargo. Ante el cargo imputado, ¿cómo se declara entonces?
Me declaro inocente.
I plead not guilty.
I'm sorry?
Perdón.
I thought you were accepting a guilty plea.
Pensé que usted estaba aceptando el dictamen con la sentencia de culpabilidad.
Eso hice.
Is that what I did?
Okay, do you need to talk to your attorney again?
¿Quiere hablar con su abogada de nuevo?
Sí.
Yes.
Bueno.
All right.
Does he not understand that he's pleading guilty?
¿Usted no entiende que se está declarando culpable para recibir el dictamen?
No entiendo.
I don't understand.
Yes, Judge, we'll probably have to do another three-way and call him. Can we take the other cases ahead?
And save him for last?
Because I have those cases.
Okay.
Vamos a tener que llamarlo de nuevo, señor, en un rato y hacer todo de nuevo.
Deputy, I apologize. Can we take Ms. Helen's other cases? And then I'll have to come back to Mr. Martinez.
Okay.
Position number 7. Oh, I'm sorry, this position 1, probation case.
Yes, that's my case, Judge.
Okay. This is 22 CR 001271J, Aaron Spencer, charged with 1 count of battery, substantial physical harm. The offense date is March the 8th, 2022. Probation.
Good morning, Your Honor. How you doing? This is Ms. Harris, your probations.
Right, good morning. How are you?
I'm doing good.
All right, what do you have?
Yes, Your Honor. Mr. Spencer was sentenced on March 22nd, 2022 to complete a drug and alcohol evaluation and 40 hours of community service. As of today, Mr. Spencer has not reported to her office. He did have a previous revocation hearing with Judge Benson on August the 25th, which he failed to report to, and that's why a warrant was issued for him. Probation is, I'm sorry, Your Honor, he has 6 months and 10 days remaining on probation. Probation recommendation is to continue on probations to get those conditions completed.
And yes, Judge, I spoke to the probation office with this petition. When I looked up his information, Judge, he had reported homeless. There was no mailing information listed. And so, Judge, we are asking for you to follow the probation recommendation. There is a recommendation for him to report as soon as he's released because of the contact issue of being residentially challenged. So yes, Judge, we're asking to follow that recommendation and just have him to release or report within the 48 hours upon release.
All right. Pretrial. What do we have on the history? Or I guess I could have asked probation.
Right, because we don't.
I thought about that as I was saying it. So I apologize for that.
No worries.
I forgot we were doing a probation case. Ms. Harris, what's his history like?
Besides this charge, Your Honor, I'm not aware of any previous offenses or anything.
Oh, okay. All right. Well, I will order that we continue based on the recommendation of the probation department, that we continue with the probation, the 6 months and 10 days left. And I will tell you, Mr. Spencer, you're getting a pass today a little bit. And so you've got to report. You've got 48 hours to report to pretrial and do what you need to do, or else you'll be right back here. Can you do that?
Ma'am.
And Judge, can I give him the address? 132 Mitchell Street, Suite 2, Atlanta, Georgia, downtown, okay? 48 hours, Mr. Spencer.
Thank you.
Thank you.
All right, good luck to you.
Thanks.
Honor, am I coming to the courthouse or do I need to send a petition and award dismissal to Ms. Champion?
Send it to Miss Gray. Oh, you're coming? Oh, Miss Grace would like to see you.
Okay, I can come to the courthouse. I'll be on my way.
She didn't say that. I threw that in. All right, yes, if you could bring it over, we would be grateful to bring it over.
Yes, Your Honor. If I don't make it, can I send it to Ms. Grace?
Yes,
Okay, thanks, Your Honor. That concludes my business. May I be excused?
yes, you may. Thank you.
Position 5.
Okay.
And this is an arraignment, Judge.
Okay. This is case number 18 CR 010895Y. Mr. Is it AC Broders or Broaders? Not for sure mispronouncing your last name. It's position 5. Mr. Broaders?
Sean.
Okay, I wasn't for sure if you could hear me. Did you hear me?
Yes, Sean.
Okay, good. You're charged with 1 count of discharge of a firearm on or near public highway or street, 2nd count of battery family violence, and a 3rd count of battery against a female who was pregnant, all with the offense date of December 16, 2018. And Mr. Finley, do you waive the formal reading of the accusation?
I do.
Okay, all right. And so is it Mr. Broaders?
Yes, Sean.
I didn't want to mispronounce your name. You have been charged with these 3 charges that I just read to you. And you've been formally accused by the Solicitor General's Office of Fulton County. And each of these charges carries a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each of those charges. These cases will be reset for a jury trial, and that trial will be scheduled by the state court judge to whom the case is assigned as further notice for trial. At the jury trial, you will have the right to an attorney. You do not have the burden to prove the charges at trial. The state, represented by the Solicitor General's office, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each of those charges that could run currently or consecutively. Based upon this information, do you plead not guilty to these 3 charges?
I do, Your Honor. Not guilty.
I accept your plea of not guilty. Your case is being arraigned and it will be reset for the notice for trial, okay?
Okay, thank you.
All right, thank you.
Next, y'all, we have position 32 and position 33, Mr. Rodney West.
Okay.
I know my lawyer, Ms. Helen. I told you that you were next. Muchas gracias. ¿Es todo por ahora?
All right, Mr. West.
Yes, ma'am.
All right, this is case number 22 CR 003905D. You charge of 1 count of battery family violence and DUI, driving under the influence of alcohol last state with the offense date of June 19, 2022. And on this case, if this is a plea?
Your Honor, is this Mr. West?
Yes.
So Mr. West is 2 positions. He's position 32 and 33. 33 is a negotiated plea. 32 is a non-negotiated plea with some issues, some things at issue there.
Let me do 33 first.
Understood, Judge.
22 CR 005969D. Mr. West, in that case, you're charged with DUI, less safe, with the offense date of September the 3rd, 2022. And I understand that you want to plead guilty to that case. Is that correct?
Yes.
Okay, State?
Thank you, Your Honor. The recommendations 12 months, serve 36 days, credit for time served 18 days, balance probated, a $1,000 fine, 240 hours community service, a risk reduction class, VIP, ADET. And this case was going to run consecutive to position 32.
Okay. All right, and I could do the plea on this one first, and then we'll do 32. Let me swear you in, Mr. West. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, and again, I'm going to ask you a couple of questions just to make sure that you have an understanding of the plea. Ms. Helen, do you stipulate the venue, identity, and a factual basis?
I do, Your Honor.
All right, are you under the influence, Mr. West, of any medication, drugs, or alcohol at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty today?
No, ma'am.
Are you prepared to waive these rights today?
Yes.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
I'm not on probation, Your
Right, I said if you were.
Oh, yes, I understand.
Okay, and do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
Okay, I will accept your plea of guilty in the 969D case to one count of DUI. Now, do you understand your conditions of your probation? And that's 12 months to serve 36 days, credit for time served 18 days, balance probated. You have a $1,000 fine. You have 240 hours of community service, risk reduction class, the VIP, which is a victim impact panel,
Yes, ma'am.
ADET, which is alcohol, drug evaluation and treatment, and a VIP consecutive with the other charges in the other case of 3905G, which we'll get to next. Those are going to run concurrent. Is that correct?
Yes.
Yes, so
All right.
I'm sorry, I said consecutively.
Oh, I'm sorry, consecutive.
Yes.
I'm sorry, consecutive to that one. Yes, I see it here. I apologize. Right, to run consecutive. I will waive 6 months of your probation fees just to help you get going there.
Thank you, Your Honor.
Okay, and so now let us get back to 22 CR 003905G on this case with the offense date of June 19th, 2022. State.
Okay, for count one, the recommendation is 12 months, serve 50 days, credit for time served 25 days, balance probated, family violence intervention program, no further contact, and a stay away from the incident location. As it relates to count two, it would be 12 months, serve 50 days, credit for time served 25 days, $300 fine, 40 hours community service, and then the risk reduction VIP ADT, that would be, okay. But for count two on this case, Your Honor, it will run concurrent with count one. So this case would have a total of a 12-month probation.
Okay. Got it. All right, Mr. West, I'm going to ask you the same questions regarding this plea.
Judge,
Sorry.
I wanted to, I didn't know if I would be able to give a little explanation as to why it's non-negotiated and some of the issues before we go into any plea questions.
Okay,
So some of the things that were at issue were the stay away and the no further contact. Ms. West is on the line. I think she wants to speak to those two specific points. If Your Honor would give her just some moments to speak about that. But also just a correction in the jail time. The offer is served 50 days, credit for time served 25 days. For jail time and the sheriff purposes, if that could be equal to a time served deal of 18 days, a credit for time served 18 days to serve 36 days. So that would be a time served deal that we're asking for, again, with the conditions, with all of the listed probationary conditions. But again, we just wanted that jail time to be equal to time served, which would be credit for 18 days served, and then serving the 36 days.
okay.
And again, I believe Ms. West is on the line. She's going to speak to the no further contact and the stay away from the Alpharetta address, Your Honor.
All right, Ms. West.
Good morning, Judge.
Okay, good morning. How are you?
I'm good, thank you.
Good. Let me swear you in if you want to address the court.
Yes, ma'am.
All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and are you married to Rodney West or?
We are currently married, but there is a divorce order that is it's already in place. It's supposed to take effect October the 19th. So he's already been served his paperwork for that.
Okay, all right. And so it sounds like you all do not reside together?
Yes, Rodney lives here, but well, up into his second DUI, which was September the 2nd. He does reside here. However, we were definitely on the verge of divorce because he has an alcohol problem where he becomes extremely verbally abusive. Not just to me, but to family members, to children. And, you know, I just felt like for my own sanity, I had to go ahead and file divorce so he could not, you know, so he couldn't come here. It was, you know, he's extremely violent when he's drinking. He has a history of schizophrenia, you know, he just has mental issues and is magnified when he drinks. He doesn't think he has a drinking problem. And therefore I can't trust him to come back, you know, without stipulations. You know, I know he doesn't have anywhere to go, and I'm not, you know, and I understand that, but however, you know, he can't come here because he won't do the right thing. That's the only thing I can say.
Okay, well, you heard the conditions, and I'm inclined to order no further contact and stay away from your address for your protection. So I would order no further contact with Tammy West, as well as a stay away. What's our address?
I'll get that.
220 Tanner's Court, Alpharetta.
Spell that.
Tanner's is common, T-A-N-N-E-R-S.
T-A-N-N-E-R. Okay, Tanner Court.
Yes, ma'am.
Okay, Alpharetta. Okay. All right. So if I were to accept this plea, Mr. West would have to find somewhere else to live. And I'd let him come one time with the police escort if there's any other belongings that he needs to get from that location. That's what I usually order.
Miss West did mention that there's a rental car, I believe, at her garage, and she's concerned about that. Is that right, Miss West?
Right. He does have his own vehicle. I have already put most of his belongings inside of his vehicle, even though I know that he's not, he surrendered his license, the first DUI, in June. when he first got the first DUI in June. He surrendered his license. So he does have someone that can come and get his car, you know, for him and what have you. And I do want to let the court know that he does have injuries due to a work related. So a lot of his mail is here. I don't, you know, until he can get situated, I can, you know, I want someone to be able to get his mail, you know. I don't have a problem with that. I don't even have a problem. Let me just state, Judge, to you, I don't have a problem with Mr. West here. It's just when he's intoxicated, and I can't trust him to stay unintoxicated. You know, he'll say that he's going to do right, but I can't trust that.
Well, I don't want to at this point until he starts his treatment and begins on a path of sobriety. So that's why I'm going to just order no further contact with you. And I'm letting you know this is for your safety and protection. So please honor the court's order as well. And he is to stay away from your location. So again, I am fine with you making sure he gets his belongings, but he is to not have any contact with you. So you're going to need to arrange that through another third party so that you don't put yourself in jeopardy, or even, you know, Mr. West won't be around you to even have any of those things happen. But do look out for your safety. So have some third party, as you stated, to come and pick up his car, put all his belongings in there, and you can put the mail in there, I guess, as well. So that, because he's got to stay away from that address, so he cannot come back to get his mail. And I'm saying that, and I know Mr. West is listening, he can't go back to that home at all. If he does, then you need to call the police. So hopefully Mr. West will honor that and honor the court's orders and conditions, or else he will be back in jail.
And Your Honor, a simple solution to the mail is the defendant can go to the postal office and give them a forwarding address for all his mail going forward on a continuing basis. So therefore, he doesn't have to worry about a third party coming and pick up the mail. So I think we've all done it before. You can go to the post office and you can give them a new address to have them forward any mail that you may receive in the future.
Now, I understand that I'm talking about for the mail that she has there now. And if she's putting everything into the vehicle to be put in there, so that whoever comes to get the car will have the clothes, the mail, all those things. Yes, Mr. West, obviously you've got to change your address. You can have the mail stopped, Ms. West, by letting them keep it at the post office, and he can go pick it up there until he has a new address for you to be forwarded to, but you can stop.
I'll do that. I'll do that.
And they can hold it there at the post office for him to pick up. You understand that, Mr. West?
Yes.
So that you don't have any reason to come there and to be rearrested.
Yes, Your Honor.
All right, and so I will accept as part of the plea the service of 36 days serving time and 18 days credit for time served. I would be inclined to go with that so that Mr. West can get started on his treatment.
And I just want to make sure, 'cause I believe, I could be wrong, but was the announcement that you guys were asking for a NOLO plea? Because if so, we absolutely would be opposed to the NOLO. I believe he just took a plea to a DUI and he has 2 previous DUIs. And I saw a simple assault conviction somewhere in his history as well, so.
Sounds like he doesn't qualify for a NOLO.
So yes, Judge, we were requesting a NOLO. We were trying to see if he had utilized it in the last 5 years, and if he qualified for it. So yes, Judge, if they could read his history, Your Honor.
All right. Do you have that, Ms. Harrison?
20 cycles. Last arrest was June of 2014 for DUI under the influence. That was a conviction. I'm showing a 2004 driving while license suspended. 1 moment. He has a 2010 driving while under the influence. That was a conviction. And a simple assault, criminal damage to property conviction, 2007.
So it looks like the most recent you have is 2014.
Yes, Judge.
Oh, well.
Well, the state's position is he has now 3 DUI convictions, if you include the one he just took 5 minutes ago. And then, I mean, technically, last time I checked, your 4th DUI was a felony, but I'm not gonna go down that rabbit hole. So this technically would be his 4th DUI. So whether he's used the NOLO on a DUI in the last 5 years or not, to me, is neither here nor there. Most judges don't accept NOLOs on DUIs anyway. But considering his history, the state will be adamantly opposed to a NOLO, especially since it's his 4th DUI.
No, I agree with that, Mr. Walker. I guess we just, like you say, just play it to 1. I would not be inclined to accept a NOLO. I don't even see that it would matter, to be honest, at this point with his history. So I've given the grace on the days for serving time and the credit for time served with the 18 days, but I will not accept a NOLO plea.
Understood, Judge. Mr. West, would you still like to move forward with the other case? The judge is not going to allow you to use that NOLO plea.
Yes.
Understood, Judge.
Okay. All right, we'll go ahead with this plea. Mr. West, I've already sworn you in, and I'll ask you the same series of questions to this case with the offense date of June 19th, 2022, okay?
Yes, ma'am.
All right, again, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And are you, do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone promised you a lesser sentence to plead guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And again, as to the charge of battery family violence, how do you plead?
Guilty.
And as to the charge of DUI and less safe, how do you plead?
Guilty.
All right, so I will accept the plea. I will read the conditions again as to count 1. That is 12 months to serve, 36 days, credit for time served for 18 days, balance probated, FVIP, which is a 24-week program. Govern yourself accordingly on that. No further contact with the victim, Tammy West, and to stay away from 220 Tanner Court in Alpharetta. You're not to go back there. I understand that there is a car with your belongings and mail inside of that car at that location. You are to send a third party to retrieve that car, because I assume you can't go because you should not be driving.
Yes,
So
ma'am.
you need to arrange with that third party to contact your soon-to-be ex-wife, not you, but this third-party person who's going to go get the vehicle, and they can arrange with her what time she will be there for them to come and retrieve the vehicle with your belongings inside. You are not to return to that location.
Yes.
And then that's going to run concurrent counts 1 and 2. What is this? I also see 40 hours of community service. State, correct me if I'm wrong. Another risk reduction VIP ADET on this case as well. Is that correct?
And a $300 fine on this one.
Oh, I'm sorry, and a $300 fine, yes.
And
Okay.
just to be clear, the two cases are running consecutive, correct?
That's correct.
But the first and second charge are the concurrent as far as that.
Correct.
Yeah,
Correct.
I think I said that right, but I might have.
You
not.
did,
Thank
Your
you.
Honor.
Okay, I appreciate it. And so are there any questions, Mr. West? Because I hope you're gonna tell me you're on your way to sobriety.
Oh, yes, ma'am. Yes, I understand clearly. You know, I just got to find somewhere I want me living at. That's all I got me living arrangement. Because like I said, I was hurt on the job. So my thing is, I just got to call my lawyer and see where we at for taking my, doing my MR treatment and see if my worker come, pay me check every week. That's all.
Okay, well, I will wish you good luck. You have a lot of conditions here, so keep in touch with Ms. Helen, your attorney, to make sure that you are completing them timely and getting them done. Because if not, you will have to, that FVIP is a long program, and you would have to start over and to make sure you get these evaluations and find out what they recommend for you and follow those.
Yes, ma'am.
All right. Anything else, counsel, that we need to take up?
No, Judge.
Okay.
Nothing further for the state.
All right, that will conclude your cases. Good luck to you, Mr. West.
Position 27.
And Ms.
Judge.
West.
Let's finish, let me finish up with 21.
Okay, yeah, let's go back to that one.
And excuse me, Judge, I just have a quick announcement. I know previously we handled my client, Mr. Butler. I just wanted to let you know that his wife is on. We ordered a no further contact, and she just wanted to address that. I don't know how you want to handle that, but I just want to let you know that she's on.
Okay, I did not notice and didn't mean to overlook you, Ms. Butler. Oh,
Well, I think-
okay.
I think
You were
she
not
was
on
back.
earlier. I didn't overlook
Correct.
you, did I? Okay, I was gonna apologize if I overlooked you.
Yeah,
But
no.
we have already taken that plea in that case. And I remember factually, and I wrote in my notes, this pattern occurred.
One second, I think she might have froze, so let me make sure that.
Ms. Butler, can you hear us? You might be correct. Ms. Butler? May have to sign off and come back in if she can hear us.
Okay, I'll reach out to her.
Okay.
While we're waiting, can we do position 27?
Yes, sir.
Hey, Judge, I thought we were on 21 just to finish up. Hey, Glenn, let me finish up 21. Then we
Is
go-
21 ready to be finished? Have you spoken to him, Ms. Helen?
I have, Judge, and he just had a mishap of understanding. He understands, and we just need to go through the plea questions with the interpreter.
All right, Madam Interpreter, we're going back to 21.
Yes, Your Honor.
This is 22 CR 0059708.
Este es el caso 22 CR 005-970H.
And Mr. Martinez, I'm going to go through the plea questions again with you.
Señor Martínez, yo voy a repasar las preguntas de su declaración de culpabilidad de nuevo con usted.
Muy bien.
And
Very well.
all right, and so for the record, so that it will be clear, with our court reporter, I have to start over again, and I'm going to start from the beginning, and that is as to the plea of SB. How are you pleading today? As to the charge of SB, how are you pleading today?
Como tengo que volver del principio a donde dejamos debido a ayudarle en su trabajo de la taquígrafa, yo quiero preguntarle a usted y le doy solo las iniciales de su cargo, ¿cómo se declara ante el primer cargo con las siglas en inglés SB?
Culpable.
Guilty.
All right, are you under the influence of any medication not prescribed to you, drugs or alcohol at this time?
¿Está usted bajo la influencia de alguna droga que no haya sido recetada en este momento?
No.
No.
Are you satisfied with the services and representation of your attorney?
¿Está usted satisfecho con el servicio y consejo de la abogada?
Contento.
I'm happy.
All right, and do you understand that by pleading guilty, you're giving up and waiving the rights?
Usted entiende que al tomar esta declaración de culpabilidad, al declararse culpable, usted renuncia a su derecho de llevar su caso a juicio, ¿entiende?
Entiendo.
I do.
Waiving the rights to the presumption of innocence?
Usted va a renunciar a que se lo considere inocente en un juicio, ¿entiende?
Entiendo.
I do.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Usted va a estar renunciando al derecho de guardar silencio y no declarar en su contra en un juicio, ¿entiende?
Entiendo.
I do.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Entiende que usted renuncia a su derecho de tener un juicio en su caso ante un jurado o ante un juez, ¿entiende?
Entiendo.
I do.
And you're prepared to agree and waive these rights today?
Y usted está preparado y está de acuerdo con renunciar, no usar su derecho de ir a juicio en su caso.
Entiendo.
I understand.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
¿Hay alguien que le haya dicho que usted va a recibir un dictamen o sentencia menor si se decide declarar culpable?
Entiendo.
I understand.
All right, and has anyone promised you anything to plead guilty?
¿Hay alguien que le haya prometido algo en especial para hacerlo declararse culpable?
No.
No.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
¿Hay alguien que le haya prometido una sentencia menor a la que va a tener si se declara culpable?
No.
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Usted entiende que si usted estuviera cumpliendo libertad condicional en otra ciudad, en otro lado, esta declaración de culpabilidad podría, en ese caso, cancelarle la probatoria. ¿Entiende ese concepto?
Entiendo.
I do.
And do you offer this guilty plea freely and voluntarily?
¿Usted se está declarando culpable libre y voluntariamente?
With the full understanding of the charges?
I'm sorry, Your Honor. One moment, please. Perdón, ¿qué me respondió, señor?
Voluntariamente.
Voluntarily. Libre y voluntariamente.
Libre y voluntariamente.
Freely and voluntarily, Your Honor.
Yes.
You may continue.
Okay, with the full understanding of the charges against you?
Esta declaración la hace entendiendo los cargos que le imputaron, ¿cierto?
Sí, así es.
Yes, that's right.
Okay, I will accept the plea.
Yo acepto su declaración.
And the conditions are?
Y estas son las condiciones de su libertad.
12 months to serve 90 days.
Son una sentencia de 12 meses.
Wait,
pero,
Your Honor, that's not a time served plea that.
Hold on. Well, I was piecemealing it.
Oh, okay.
Okay.
I was trying not to give the whole sentence for the interpreter.
Ok, estaba tratando de dar la sentencia en trozos. Son 12 meses de sentencia, pero para servir 90 días y...
With credit for time served 17 days.
Y dándole crédito por los 17 días que ya ha servido.
Balance suspended.
Y se le suspende el resto para cumplir los 90 días.
No further contact.
No puede tener más contacto futuro.
With the victim Ashanti Carter.
Con la víctima llamada Ashanti Carter.
SDET, which is an evaluation.
Tiene que usted hacerse una evaluación.
And stay away.
Y tiene que mantenerse alejado de...
No, stay away. I'm sorry.
Perdón, no, incorrecto.
It's no further contact with the victim. I said that.
No
And-
más contacto con la víctima.
And I'm very cautious about allowing him to go back onto MARTA as long as he can hopefully have no more incidents.
Tengo mucha inquietud en permitirle volver a Marta, a no ser que usted no tenga más incidentes en esa compañía de transporte.
¿Puedo hacer una pregunta?
May I ask you a question, please?
Hold on one second.
Un momento.
If he is riding MARTA and sees the victim, he is to go the other way or go back to jail.
Si usted usa el transporte de Marta y usted ve a la víctima, a Shanti Carter, usted debe retirarse de inmediato, irse en otra dirección o volver a la cárcel.
Primero, no conozco a la víctima, nunca la he tratado, nunca la traté.
I don't know the victim. I never had any communication with her.
We understand, but there's a strong allegation here, and I'm accepting the plea as long as.
Yo entiendo eso, señor, pero hay un serio alegato en su contra por parte de la víctima, y esa es la condición para que yo poder aceptarle esta declaración y usted poder salir y cumplir.
As long as he stays away, and if he sees the victim, that he has no further contact with her.
Mientras que usted cumpla con mantenerse alejado, y si usted usa el transporte y la ve a la víctima, usted tiene que no tener ningún tipo de contacto y alejarse de inmediato.
Okay?
Okay? ¿Está bien?
Está bien.
That's fine.
Okay, and I don't know, correct me if I'm wrong, ASG Reed, did I say balance suspended or balance probated?
Well, you said balance suspended, but I think if he has the program, he'll need to be on balance probated. But you wanna-
Probated, right. I was making sure I said the right thing, balance probated, correct.
Well, Judge, you also told him 90 days. Were we still giving him the time served? And it would be 34 days to serve and credit for time served, 17 days.
Correct me, thank you. Yes, that should be, let me correct myself on that as well. It should be to serve 34 days, credit for time served 17.
Entonces sería para servir 34 días y se le da crédito por los 17 que ya ha cumplido.
Anything else that I need to correct? Make sure we're all clear or the record is clear.
¿Alguna corrección más?
I just want the translator to tell him to report to the probation address of 132 Mitchell Street, Southwest Atlanta, Suite 2.
Suite 2?
Yes, ma'am.
Thank you. Señor, su abogada quiere comunicarle que usted, una vez que salga, tiene que presentarse en la oficina de probatoria, que es de 132 en Mitchell Street Southwest en Atlanta, y la suite es la número 2. Will he receive this information?
¿Cómo obtendré la información en mano?
How can I get that information in hand?
If they can write it down for him there.
¿Hay alguien que pueda escribírsela por usted? ¿Tiene?
Deputy?
Excuse me, do we have a contact number for him? I can text him once he get out if you have a contact number.
We don't. He's homeless with no phone.
Okay. All right.
Deputy, is there any way, I know you're going to get me for this later. I'm sure you don't have any scratch paper there, do you?
Anybody else say something? I'm resetting y'all. That's my word. And you should-
I understand. I was trying to just see if they could give you that address. Since we don't have a way to contact you, but the deputy's gonna get me for that later.
No, not at all, Your Honor. I had to tell some other people, they need to be quiet because he's taking a plea.
Okay. Do you have paper and pen there?
Yeah, I do.
You do? Okay.
I got you.
I was like, I don't know. I appreciate that, Deputy. If you could give him that address.
What's the address again? Did they put it in the chat?
132.
Oh, okay.
Yeah, if you could put it in the chat, it'd be much easier.
I'll send
Okay.
it. I'll send it.
All right, thank you. I appreciate that.
Your Honor, with your permission, the interpreter would like to know if there is a date when he has to be present or as soon as he can.
Ms. Helen?
I didn't understand that part.
We're
Miss
asking
Helen,
him
How
to
much time
report
does he have to report?
to probation as soon as he's released.
Okay, thank you. Señor, en cuanto usted salga y lo pongan en libertad, usted debe ir a esa dirección, por favor.
Ya tengo la dirección, ¿cómo voy a obtener la dirección? ¿Cuándo y cuándo voy a salir?
So how am I gonna obtain the street address and when am I gonna get out?
The deputy is giving him that address now on a piece of paper that I hope he can keep up with until he's released.
El oficial le está dando a usted la dirección y por favor guárdela hasta que lo pongan en libertad para poder ir. ¿Entiende? Do you understand?
Muy bien.
Very well.
Nothing further from the defense, Judge.
Nada más de la defensa.
All right. That should conclude this case.
Thank you, Judge.
All right. thank
Así
you.
se cierra su caso.
Muchas gracias.
Thank you very much.
Right.
Your Honor, I think that's the only case the interpreter had. May she be dismissed.
All right. Thank you, Madam Interpreter. Appreciate your time today.
You're welcome. Have
Thank
a good
you.
day, Your Honor. You're
Have a-
welcome, madam.
All right.
And Judge Mincy, Ms.
Yes.
Butler is on. I don't know, she's took a break from work. She wanted to get on the Zoom. And
Go ahead, Mr. Finley. Go ahead.
oh no, it's just Miss Butler, who we addressed her husband earlier, with the no further contact. I let her know, and she was unable to get on the Zoom because she was at work. So I know she just wanted to come on and say something, I believe. If that's
State, if you will indulge me for a few minutes, it won't be
Oh, the
long.
state would love to, Your Honor.
It won't be long, because we've already
Proceed with
heard,
caution.
yes, because we've already heard this case, Ms. Butler. And, generally, we would try to bring the defendant back, but that's not going to be possible with the jail and their logistics. So, I did hear the facts of the case and what the allegations are. And that's 22 CR 006012J. I'm going to tread a little light. Raise your right hand for me. Do you affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, briefly, what would you like to tell me regarding my ruling, or now that you've heard that, what would you like to say to the court?
I would like the no further violence order instead of just complete no contact. Everything was really heated when this first happened. I chose not to pursue the TPO. I wasn't familiar with this proceedings and I should have looked into it more. Sorry, I'm going in and out. I would just like no further violence.
Well,
The state would like to address the court, Your
let me
Honor.
let you address it and then I'll give my.
So there's so many things at play, so I'm gonna try to keep it orderly, if you will. When we first made contact with the victim, she made it very clear to our victim advocate that she did not want the defendant to return, that she was in fact fearful and she did not want contact. You actually were the judge that saw Mr. Butler, I believe, at his first appearance on C calendar. You initially gave him a signature bond, which included a no contact. Mr. Butler was so bold as to, once he was finished with his hearing, after you ordered him not to have contact with Mrs. Butler, he went back to the general area, the cell phone area, the phone area, and called Mrs. Butler after you ordered him not to have contact. Therefore, he was brought back to court and you changed his signature bond to a good bond. So if he cannot follow instructions after receiving them 30 seconds from the court that he's not to have contact, and you change the signature bond to a surety bond for that reason, and the victim stated on that day that she was in fact fearful and that she did not want him to return and she did not want contact, we are sticking by the statements that she made that day. We are very concerned for her safety. The defendant has clearly demonstrated in front of the court that he is not going to follow the court's orders, and that's why you changed his signature bond from a signature bond to a surety bond. So the state stands by its position. We are adamant about the no contact order. We took the victim very seriously when we first spoke to her about this matter. I can pull more jail calls if I need to, because if I had to guess, if I were to do a search, there would be more than one call. But he called the defendant actually while court was still going on that particular day. So if that's indicative of anything, it speaks for itself, Your Honor. So we ask that you maintain your prior ruling.
I do remember this case. I hadn't had that to happen to me before, so it was a little bizarre. So I do remember this case, Ms. Butler, and I remember, again, the fact that you told me on that day that you did not want any contact with him. And we also ordered him to continue his AA meetings. I'm looking at my order from September the 7th, okay? And so what we have to do, there hasn't, again, been the proper cooling down period, as we call it. And the solicitor's office with their victim witness assistance program, and employees are able to give you some assistance to help you during this period as a victim of this case, and to offer you certain services that may assist you. So I'm not going to change my ruling at all, because I do remember this case and was a little alarmed by the fact that he heard my ruling and 30 minutes later was having contact with you. You stated that you did not want that contact. So there are processes and procedures in place. And we want to obviously make sure, number one, is that you are safe. And so if he is able to get out on bond, I'm going to stick by my order and continue that. He's to have no further contact with you, and he is to stay away from 822 Ashley Lane. He gets a one-time police escort to come back to retrieve his items. And so he is to not be at that location, or else he will return right back to the jail and to continue his AA meetings. So that is.
I'm sorry, did we have a bond hearing earlier, or was it a plea?
Earlier. Well, I'm sorry, earlier he pled.
Yeah, it was a non-negotiated, Ian.
I'm sorry.
Yeah, so once he gets out,
Thank you
course,
for
to the
that.
plea,
Yeah.
he's not.
I'm
gonna have
sorry.
that.
He's got certainly many more conditions now, and I apologize. But he now he received credit for time served at 15 days, but he has to do an ADET, which is an evaluation, and whatever the recommendations are from the ADET, he must comply with those. But to stay away to no further contact, or what he just pled guilty to, and I'm certainly not going to go back and change that as well. And I understood that you may have. Is this the case where it said it may have a TPO filed or pending?
That's correct.
So I think you need to continue on that road and ensure your safety as well. And if you need any assistance, the solicitor's office has persons in place that can assist you with that and making sure that you are safe. But I'm not going to allow no further violent contact. I'm going to continue on with no further contact with you. So trust me, you need that for your safety, and I hope that that continues to work out for you. Okay. All right.
Your Honor.
All right. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
And who do we have next, deputies?
Your Honor, can we do Mr. Wilson? He's position 36.
That's a negotiated plea, Your
Okay. This is case number 21 CR 006162A. Dory Wilson, you're charged with one count of theft by taking. Offense date May 8th, 2020. State?
Thank you, Your Honor. I'm just pulling that one up as we speak.
Okay.
Okay, the offer on this was 12 months to serve 365 days, credit for time served 173 days.
All right.
Yes, Judge, that is our understanding of the plea. We do accept it. We stipulate to the factual basis, venue, and ID.
Okay. Hmm. Oh, all right. And though there are no other conditions, no, that's it, correct?
That's correct, Your Honor.
Okay,
Correct, Judge.
all right. Mr. Wilson, can you hear me? Think you muted. Okay. Mr. Wilson, can you hear me?
Yes, ma'am.
All right. I have been informed about the plea in your case. And are you willing to plead guilty to this theft by taking?
Yes, ma'am.
All right, I'm going to ask you a series of questions in order to make sure that you understand. The first one being, are you under the influence of any prescribed medication, drugs, or alcohol at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, I understand.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you prepared and agree to waive these rights today, is that correct?
No, yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am, I understand.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your plea. That is 12 months to serve 365 days, credit for time served at 173 days.
Thank you.
All right, good luck to you.
Thank you, Judge.
All right.
Thank you, Judge.
Your Honor, we're completed here in courtroom 2. We still have the officer that's roving from floor to floor. We want to give him time to log on with the rest of the positions on the calendar.
Okay, that sounds good.
27.
Actually, I didn't, did I? I did not. Mm-mm, mm-mm. So we're in Fort North. Who do we have?
Position 27.
Okay. Mr. Scott? This is case number 22 CR 005976C. Is it Jarquez Scott?
Yes, ma'am.
Okay, I have 5 charges here. Speeding, no proof of insurance, knowingly driving a motor vehicle on a suspended, canceled, or revoked registration, driving without a valid license, and possession of marijuana less than an ounce. Is that all with the offense date of 6/18/2021?
No, Judge, I saw that some of those have like a different offense date. like
Right.
June 8th.
State, can you clear that up
Yeah.
for me?
Well, I saw that too on Odyssey, but when I look at the accusation, all of the dates are 2021. So
Okay.
that's like some sort of internal
Typo,
error
we'll
that,
call it.
but
Okay,
but all the accusations read the same date.
okay, for June the 18th or the 8th?
June.
I'm sorry?
It's what is on the calendar. I may have written it
Well,
wrong.
but no, it's conflicting on the calendar as well.
Yeah, I have 2 separate dates for
So
2.
is it June 18th, 2021 or June 8th, 2021?
Okay, I thought it was, one of them said 2020, and that was
And
the
one of them
conflict.
does say 2020 as well.
Correct, Judge.
All kinds of different dates.
Correct,
Okay.
Judge.
Let me look at the accusation.
Okay.
I'm sorry, Judge,
Miss-
what
Miss-
position is this?
Position 27, Ms. Grace is looking as well. And I'm assuming all of these occurred on the same day, I'm guessing.
Well, we're guessing, Judge.
So what does it have on that first one? The 18th, looks like June 18th, 2021. Okay, now she's going to the next one. Let's see. Okay, June 18th, 2021. I think that's going to be our date, but she just wants to check each one and make sure.
Valid license is June 18, 21.
Okay. Okay. So we got one more. We're just checking them all just to be on the safe side. So there won't be any issues later.
These are all activated June 18, 21.
Okay. All right. Looks like all of them should be June 18th, 2021 is our offense date for all 5 of those charges. All right, Staten, you may go ahead and proceed.
And so we're just doing a bond hearing on this one?
Oh, okay. This is not.
Correct. This is a bond hearing, Judge.
All right. You know, I was in a different mode, so thank you for bringing me back.
For our recommendation for the bond, it's just going to be, a 2,500 signature bond, and that will break down to $500 per count signature bond.
And if we can have free trial, read the history, and Ms. Reed, if you can give a factual basis, please.
Yes, sure. Okay.
Well, let's let pretrial go and then I'll come back to you, ASG Reed.
Okay, 10 cycles. Last arrest, July of 2020 for probation violation in DeKalb County. Underlying charges burglary in the first degree. Record indicates an open probation for possession of MDMA, possession of cocaine, possession of marijuana with intent to distribute, possession of firearm by first offender probationer, and that's in Fulton County, 18 SC 158668. That's an open case. There is a probation case for, one moment. I'm sorry, it is probation. It was sentenced May of 2018 with 5 years confinement and 10 years probation.
I apologize, Judge. She froze. I didn't hear the last couple minutes.
Okay.
Okay,
Repeat that again. Yeah, now we can repeat that again.
Okay, so 10 cycles. Last arrest is for a probation violation in 2020. Underlying charge was burglary in the first degree out of DeKalb. Record indicates an open probation for possession of MDMA, possession of cocaine, possession of marijuana with intent to distribute, possession of firearm by first offender probationer in Fulton County. Case number 18 SC 158668. Sentenced May of 2018. 5 years confinement, 10 years probation. Record also indicates an open probation for burglary in the first degree, possession of marijuana with intent to distribute. Case 20 CR 27107. That was in DeKalb. Additional open probation. One moment, I'm sorry. That was sentenced June of 2021 with 2 years probation. Nothing further, Judge.
Okay,
And Your Honor, he has a Superior Court case here. I'm showing 2022. It's 22 CP 209936, and he has a $24,000 split bond. So I think with this case, even with the signature bond, he still has to make the 24,000 split bond. So as for the factual basis, the date of the offense, June 18th, 2021, defendant was driving 56 miles per hour in a 35 miles per hour zone. He was pulled over and he told the officer that he did not have a driver's license. He also did not have insurance, nor did he have registration to the car. And an inventory of the vehicle found 3 small bags of marijuana in the glove box.
okay. Ms. Helen, this is your case, correct?
It is. I just want to make sure I got, before we went into his history, did the state agree to signature bonds for all of the charges?
I don't think that's what I heard. No, we did not.
So what was the suggestion of the bond by the state?
That remains the same.
And what's the bond that's reflecting? I don't see a bond reflecting for this case.
So he has a bond for his felony case that's pending.
Well, I don't, who requested the bond hearing? The public defender? I'm not even showing that he's being held on these charges, so I'm not sure what we're talking about.
Well, I have it as jail jury bond hearing on
Like,
the
when
calendar.
when I pulled him up on the Jellin screen, it said that he's being held on felonies only, so I don't know if I'm missing information. That's what I'm saying. Who requests the PD? The announcement came from the PD, so I'm not sure what we're.
Requested a bond hearing because I didn't see a bond reflected for this case at all. I didn't see that he had been arrested at all. So I wanted a bond hearing to verify what the bond was for this case.
Well, if he hadn't been arrested on this case, he's not being held on this case, and he doesn't have a bond. We can set a bond if you. I mean, if you haven't been arrested, you haven't been booked, so he's not even being held on this charge or in this case, if you will.
So he's not.
I mean, I can't give you advice, but I don't think sitting a bond would be advantageous to your client when he hasn't even been booked on the charges.
Judge, the issue here, when I spoke to Mr. Scott about this case, he was under the impression this is not him at all. So when I went to Odyssey to do more investigation with this case, he hasn't been arrested for it. And I can't see a bond for it. I can't see where he made a bond or was bond out for it. So Judge, we needed this bond hearing for more information.
He's not being held, so.
If he's not being booked yet, I can't give him a bond for a case he's not been booked on, unfortunately.
And as far as identity, that's an issue for trial, not an issue for bond hearing. So again,
So Judge, we'll arraign it for trial. And we're requesting that jury trial.
Okay.
Can I speak? No, I don't, not at this point. Hold on.
Hold on, Mr. Scott.
Mr. Walker, come back.
Hey, Judge, I'm sorry.
Right, since you're the supervisor on this, if he's not been booked on it or formally charged, can I arraign him? Because I don't think.
It probably was a citation case. And
It could have been one of the, 2021.
I don't know.
No, it was out of East Point, Your Honor, and it just says it was it says released on bond out of East Point.
So he bonded out.
Oh,
Then
so-
he has felony charges.
Right, so he's just in on the felonies. He's already
Right,
bonded
so
at East
that's-
Point on this. So
Right.
I should not be hearing anything because this is not. before the-
Well, hold on one second. One second.
You checking too, Ms. Grace? Check for me. Because if he's,
So you can arraign him because the case has been accused.
okay,
However, he's not being held on these charges. So we can arraign him, but as far as
right, but no bond. It doesn't.
I mean, we can have a bond hearing and we can set a bond.
We'll go
but
for
he's
the arraignment.
He's not being held on.
And
so.
enter a request for a jury trial, Your Honor.
Okay. All right, let's do an arraignment on this case, which is 22 CR 0059766C. And Mr. Scott, as I have already told you about the 5 charges that have been accused against you at this point. Ms. Helen, do you waive a formal reading of the accusation?
I do, Judge.
Okay. And again, Mr. Scott, you have been charged with 5 counts, which have been formally accused by the Solicitor General's office in Fulton County. And the charge for each of those carries a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each of these charges. These cases will be reset for a jury trial. The trial will be scheduled by the state court judge to whom the case is assigned as further notice for trial. At the jury trial, you have the right to an attorney. You do not have the burden to prove the charge at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each of these charges that could run currently or consecutively. Based upon the following information, do you plead guilty to each of these 5 charges?
No, ma'am.
Right, I'm sorry, and I should have asked, are you pleading not guilty?
I'm pleading not guilty.
Okay, I will accept your not guilty plea. That was my mistake there. I will accept your not guilty plea to the speeding, no proof of insurance, canceled or suspended registration, driving without a valid license, and possession of marijuana less than an ounce. So those are the 5 charges as you understand them.
Yes, ma'am. Can I please say something, Judge?
Ask a question, don't talk about the facts of your case. Do you have a question about the arraignment or the charges per se? Because if it's anything more than that, you should not be talking.
No, I'm just saying, on a lot of jail, locked over 2 years. If you see it, and I'm locked over 2 years, so it went no possible way. I was in a car with no idea. So I was in jail.
Well, that's what I'm saying. Your attorney is going to deal with that. This is not the proper forum for that. This is just an arraignment to tell you that you've been formally charged. Your attorney will handle that. She will know how to file the proper motions and things of that nature regarding the charges. And I cannot determine that as of today, okay?
Yes, ma'am.
All right, thank you. That will conclude this case.
Thank you, Judge.
Huh?
Position 35.
That's crazy.
That's a negotiated plea, Judge.
Okay. They say 20, what? 35. Oh, 35. I don't know what I thought I heard. Okay. Mr. Williams. This is case number 22 CR 006008B Giovanni Williams, charged with 1 count of simple assault. The offense date is May 23rd, 2000. I'm sorry, 1 count of simple assault, 1 count of simple battery, both with the offense date of May 23rd, 2022. State?
Yes, as it relates to count 1, 12 months to serve, 30 days. Credit for time served, 15 days. Balance probated. Stay away from the incident location, which is 780 Neal Street Northwest, Atlanta. That's, I think, Booker Washington High School. No further contact with victim, initials AG, in an 8-week anger management class. And count 2, simple battery, would run concurrent to count 1.
I'm sorry. So give us the address again.
Sure. 780 Neal, Neal Street, Northwest, Atlanta.
And yes, Judge, that's our understanding of the plea. We do accept it and we stipulate to the factual basis, venue and ID.
Okay. And the stay away address, is there a, and who, the victim again, no further contact with was it S? No,
It's AG.
AG, okay,
He's 15 years old.
gotcha. All right, and Ms. Helen, that's your understanding, is that correct?
Yes, Judge.
All right, do you? Excuse me. Do you stipulate to venue, identity, and factual basis?
I do, Judge.
All right, Mr. Giovanni
Yes, ma'am.
Williams, I'm sorry, your last name is Williams, I apologize. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, can you, you can put your hand down for me. I'm going to ask you a series of questions in order to accept your plea. The first one being, are you under the influence of any prescribed medication, drugs, or alcohol at this time? I didn't hear you.
No.
Okay, you have to speak up because the court reporter has to hear your answers. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agreed to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea?
No.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and as to the charge of simple assault, how do you plead?
Yes, ma'am.
No, as to the charge of simple assault, how do you plead?
What you mean?
Do you plead guilty or not guilty? How are you pleading to the charge of simple assault today?
Guilty.
And to the charge of simple battery, how are you pleading?
Guilty.
Okay, all right, I will accept the plea as read by the state as to count one, that's 12 months to serve 30 days, credit for time served 15 days, balance probated, stay away from the incident location, 780 Mill Street Northwest in Atlanta. No further contact with AG. There's an 8-week anger management course, and then it's to count two, runs concurrent, 12 months to serve 30 days, credit for time served 15 days. And so do you understand about that you have to take an 8-week anger management course and obviously stay away and have no further contact with AG, the victim in this case? Are you clear about that? Uh-oh. Mr. Williams? Ouch. May have to let them know that in the middle of my plea. Oh, can you still hear me, Deputy? How much time did we lose? How much? Okay. Did you hear me read those conditions, Mr. Williams? Of the 8-week anger management course, no further contact with AG and to stay away from that incident location? Did you hear me say that?
Yes, ma'am.
Okay, just making sure that you understand that, and that will conclude the plea. I will accept your plea in this case. Okay,
And Judge, it's a probated sentence, so could we have those probation fees waived for Mr. Williams?
I will waive 6 months of probation fees.
Understood, Judge.
Okay. All right, anything else, counsel?
Nothing further from the state.
No, Judge.
All right, thank you. That will conclude this case.
Thank you, Judge.
All right,
22.
okay. Twenty-two. This is 22 CR 0059993F. Mr. Morgan,
Yes.
not for sure how to pronounce your first name. You charged with 1 count of loiter prowling, and that offense date is 9/5/2022. State.
Yes, Your Honor, the recommendation is 12 months, serve 30 days. Credit for time served 12 months, serve 32 days. Credit for time served 16 days. Balance suspended and a stay away from the incident location, which is the residential area of Wakefield Drive and Camden Road, and that's CAMDEN Road in Atlanta.
Ms. Helen, this is your case.
Yes, Judge, that's our understanding of the plea. We accept it and we stipulate to the factual basis, venue, and ID.
All right. And Mr. Morgan, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, you put your hand down. I'm going to ask you a few questions in order to accept your plea today. It's my understanding that you wish to plead guilty to the charge of loiter and prowling. Is that correct?
Yes.
Okay, and so let me ask you this. Are you under the influence of any prescribed medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
The right to remain silent and not testify against yourself?
Yes.
And the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you receive a lesser sentence for pleading guilty?
You say.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
All right, and do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right, and as to the charge of loiter and prowling, how do you plead?
Yes.
All right, I will accept your guilty plea, and that is 12 months to serve 32 days, credit for time served 16 days, balance suspended, and stay away from the incident location, which is Wakefield and Camden Road. Do not go back to that area, or else you'll be back in jail. You understand that?
Yes.
Okay. All right, that will conclude the plea in this case.
Thank you, Judge.
All right,
Thank
thank
you,
you.
Judge.
Right,
All right, conclusion 30.
30, okay.
And Judge, I just need an opportunity to speak to Mr. Smith really quickly in a breakout room. I don't believe 4 North has a phone.
Oh, okay. Ms. Champion, did you hear that?
Yes, ma'am.
All right, you can just put Miss Helen and, oh, can you do that?
Yes, ma'am, I can.
Okay, I'm sorry. I thought about it and then I said, wait a minute, can you do that? Okay. We'll hold for a second.
And while that is happening, may I inquire about Darrell Davis?
What position is that?
Well, I apparently have the wrong calendar. He's position 10.
Oh, okay. Yeah, that's position 10. That's
Just wanna
going
make sure I
to
didn't miss
be-
any
it says
notes.
non-negotiated plea.
Okay, so we are still gonna handle him and as well as Quintarius Gooden.
So Gooden is not on the calendar anymore. He was, I think, mistakenly put on this one. We addressed him last week.
Perfect. And Boris Hall, we're still gonna address.
Yeah, yeah.
Okay,
So I'm waiting
perfect.
for Davis and Hall.
Thank you so much.
No
No,
worries.
that's
Thank you.
good.
Three more.
Since we only have 3 more cases, does Miss Helen want to hear it though? I forgot. We were getting ready to go reconcile, but let's wait because Miss Helen probably wants to hear it.
I think so.
And Judge, we're ready on position 30. That's going to be a jail jury arraignment only.
30 jail jury arraignment, okay.
Yes, Your Honor.
Let's see, where did they go? Mr. Smith?
They were in the breakout room.
He may need someone to come over there to take him out. Ms. Champion, are you able to assist them or we have to?
They need to log back in. The breakout room was closed, so they're connecting now.
Okay, great. All right, Mr. Smith?
Yes, ma'am.
Okay, so making sure you can hear me. I'm going to formally arraign your case. Do you waive the formal reading of the accusation, Ms. Helen?
I do, Judge.
All right, Mr. Smith, you're charged with, this is 30, correct?
Correct, Judge.
Okay, Mr. Smith, you're charged with 1 count of criminal trespass, family violence. And this is, your attorney has waived the formal reading of the accusation. And with this case, again, the Solicitor General's office has formally accused you of this charge. And it carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case will be reset for a jury trial, and the trial will be scheduled by the state court judge to whom this case is assigned as a further notice for trial. At the jury trial, you will have the right to an attorney. You do not have the burden to prove this charge at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000 based on the information. How do you plead to this charge of criminal trespass? Family violence?
Not guilty.
Not guilty.
Not guilty. All right, I will accept your not guilty plea. Your case has been arraigned and reset further notice to trial, for trial.
Thank you, Judge.
All right, thank you. Who do we have left?
I have positions 36, 35, unless we did those.
Let's see. We did 35 and 36 were pleased. Right?
Yes, that's correct.
And what was the other one, Ms. Helen?
That was it. I got those. Thank you.
Oh, okay, okay.
And then I just have Mr. Boris Hall and then Mr. Davis.
Okay.
That's correct, Your Honor.
That's position 13. As the jail, are these two, that's 13, and what was the other one?
I believe it's 10.
Okay, let's see. $13 and $10.
Can I get hall booking number?
Hall's booking numbers. Oh, I don't have the booking number. Hold on. I was going to read you the case number.
It is 2210316.
I will be back in 2 seconds, everyone.
At the next line, turn left.
Everyone, they want us to give them 5 more minutes. They're bringing Hall. Can we reconcile the calendar? Miss Grace is very efficient, so she's making us use our time wisely. Is that okay with everyone?
Yes, the state's ready, Your Honor.
Okay. Right.
Position number 1, jail jury arraigned. Position number 2 is transferred to Superior Court.
Can you all hear her?
Yes. Yes.
Okay.
Position number 3, reset 10-4, SAP. Position number 4 and 5, jail jury arraigned. Position number 6 was a plea. Position 7 and 8 were pleas. Position 9, reset 10-4, SAP. We're holding on position 10. Position 11 was a plea. Position 12, reset further notice. We're holding on position 13. Position 14 and 15, reset 927 SAP. Position 16, reset 927 SAP. Position 17 and 18, jail jury. Position 19, jail jury. Position 20, reset 927 SAP. Position 21 and 22 were pleas. Position 23, reset 927 SAP. Position 24, 25, 26, reset further notice. Position 27, arraigned, reset jail jury. Position 28 was a plea. Position 29, reset 927 SAP. Position 30, reset jail jury. Position 31, reset 927 SAP. Position 32 and 33 were pleas. Position 34, reset 10-4 SAP. Position 35 and 36 are pleas. Any questions, comments, or concerns? For one revocation, the defendant will continue on probation. Y'all come on.
I know, right? What I need.
Judge, I got Hall.
You're muted, Your Honor. You're muted, Your Honor.
I'm sorry, Mr. Hall, can you hear me?
Yes, ma'am.
Okay, this is case number 21 CR 005923A. You're charged with one count of battery family violence, offense date 10/31/2021. State.
Yes, Your Honor, the offer is 12 months to serve 140 days, credit for time served 70 days with the balance probated, FVIP, and no further contact and a stay away. The no further contact is with Jason Edward Jones, all traditional spellings, and the stay away address is 26 Cedar Run.
Okay. Is that your understanding, Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree. I would just ask that, for one, that the probation fees are waived for Mr. Hall. And then lastly, that once Mr. Hall does complete the family violence class, if the or if his probation, excuse me, can be non-reporting.
Is there history or no history? What would be?
To the state's understanding, there's no history, Your Honor.
No
Yeah.
history, okay.
So if possible, balance suspended, but if you're not inclined, Your Honor, then at least non-reporting. I think he has done 70 days, which is a lot.
All right. With no history, I'll do balance suspended. And Mr. Hall, I'm going to ask you a series of questions quickly to make sure that you understand the plea that you're accepting today. Can you raise your right hand for me? You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Are you under the influence of any prescribed medication, drugs, or alcohol at this time?
No, ma'am.
All right, you can put your hand down. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
You understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
The right to trial by judge or jury, whichever you prefer? You're giving up or waiving the right to trial by judge or jury, whichever you would prefer?
Oh, yes, ma'am.
And that, has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
Oh, my fault. No, ma'am.
All right. Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked due to your guilty plea here today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And as to the charge of battery family violence, how do you plead?
Guilty.
All right, that's 12 months to serve 140 days, credit for time served 70 days. I'm going to suspend the balance after you complete the Family Violence Intervention Program, FVIP, which is 24 weeks. No further contact with the victim in this case, Jason Jones, and a stay away from 26 Cedar Run. Can you do that?
Yes, ma'am.
All right, expect that you will. I will accept your plea and that will complete your case. Oh, I will waive 6 months of the probation fees. You got that?
Yes.
Okay. All right. Is that it for us?
Yes.
I
Thank you,
believe-
Judge. Yep.
All right, thank you, everyone. Appreciate your time. Oh, hold on one second. Position 10,
Yes, Mr. Davis.
is it coming or?
According to my coworker that will float on the floor, she told me that he gonna be a medical reset.
Medical reset for 10? All right,
Are we gonna pay him on Thursday or
yeah,
just so we have an idea?
Next Tuesday.
next Tuesday,
Y'all want to reset it to us? I can take it.
Oh, let me,
the medical reset.
I just want, let me just,
Oh, Judge Law is here with me. We can reset him till
This
is
Thursday.
this is Darrell Davis?
the Thursday. Yes,
Because this, I mean, I don't know what, Zach, what was that announced to me? It was time served. That's the only reason why I was asking.
Yeah.
I think it was
yes, is.
non-negotiated. Oh, it's not
Oh,
non-negotiated?
so it's only non-negotiated in terms of, I was gonna ask for just the balance to be suspended for him, but it is
Okay.
time served, so.
As far as the jail time, so if Thursday is possible, since the jail time we agree upon.
Yeah, yeah.
yes. Judge Law will do it on Thursday.
Great.
Thank you, Judge Law.
Thank you, Judge.
Yes,
Thank you.
that is good.
All right, thank you, Judge.
All right, thank
Bye,
you.
everybody.
Appreciate it. All right,
Thank
take care,
you.
everyone.
Thank you, Judge.
All right,
Thank you.
thanks. Bye-bye.